Copeland's testimony. Well, I guess generally Mr. Copeland's testimony. And then I'll entertain what we're going to, I am going to say about the fact that here I am instead of Judge Glanville. But I mean, for that, I'm thinking essentially just, I don't know, some matter has required a substitution of judges, and that's about it. I don't plan to tell them really much more than that. They don't need to know why.
Your Honor, given the conversation Ms. Hilton had with the defense last night, in that some of them may be seeking to have some portions of it kept, depending on the court's decisions regarding our respective positions, I don't think we can craft at this point. For instance, if we decided, everybody said, let's just keep it, then we would just keep it, understanding that's likely not going to be the case until we know the respective positions and the court's ruling on that. I don't think we could endeavor to craft it.
Yeah, that may be true. Okay. Yes, sir.
Good morning, Your Honor.
Good morning.
Good morning to everyone. Your Honor, I would, and Mr. Adams can opt out of this if he believes it, but I'm objecting to anything except the unvarnished truth about Judge Glanville. I would like the court to tell the jurors the truth, that he has been found to be disqualified and removed from this case for his conduct. And that's my instruction that I worked on. That's what I'd like you to do.
All right, well, I'll consider everything once I've got everybody's proposed instruction, to the extent anybody wants to provide one for me to think about.
Thank you.
And Your Honor, I believe that the statute, if I'm not mistaken, regarding recusal specifically, speaks to the fact that that is not to be made a portion of the case in chief, of the main case. I'll get the exact language that I'm speaking of.
All right, great. Thank you. I appreciate that. Okay. Anything else?
Yes, Your Honor. We also briefly discussed yesterday the exhibit list, talking about how we can resolve working through the exhibit list. And my understanding from Mr. Shard, I'm not sure Mr. Kokomo was finished yet, but Mr. Kokomo, who's his legal assistant, and another legal assistant, we're actually working through the same thing that our legal assistant is working through. And our hope is, hopefully the court will be okay with this. By next Wednesday, our legal assistant would have gone through every video to assure we have all of the correct exhibits. But it's taking time because she's literally watching every single time we're in court.
I'm not okay with waiting until next Wednesday. I mean, I'm hoping, and it may be a false hope, but I'm hoping that we'll have the jury back with us by next Wednesday. So that needs to accelerate.
Okay. We will work on accelerating that list to get to the court. But I believe that they're working on it as well.
Well, they need to accelerate as well if their thought was next Wednesday. I mean, like, I'm thinking this Friday, okay? Which is the day after tomorrow. All right, with regard to, and you're talking about the videos of his testimony, right? Or are you talking about?
No, I'm sorry, I should have been clear. To confirm what exhibits admitted and not admitted. That's what we've been working on. No, that's
the giant list of
list of exhibits.
Yeah, that's fine. That can be next Wednesday. That's not that urgent. As long as we've got that correct by the end of the trial, that's all that really matters.
Yes, Your Honor.
For that. I thought you meant Mr. Copeland's testimony.
No.
Okay. All right. My misunderstanding then. Okay. Video interviews of Mr. Copeland. I suspect they're parts of those that the state knows they intend to be using or suspects very strongly they probably need to be using. So can we either come to some form of an agreement about evidentiary rulings that were already made, and or let's figure out what I need to do again?
Yes, Your Honor. I believe after we had the initial arguments regarding some of the redactions, some of the redactions we did concede on. So once I get that list, I can let the.
Well, I've already seen those with regard to a couple of things, but I haven't gone through. I mean, I was looking at, for the transcripts I had, the arguments that y'all had already presented, and I saw that there were maybe like a couple, I don't know which, I can't remember right offhand which dates I've already looked at, but there didn't seem to be that many that y'all just conceded. Seemed like y'all argued and needed a ruling for most things. But what I'm saying is, having argued it once and having gotten a ruling from a judge who knows what he's doing, whether y'all like him right now or not, do I need to re-listen to each argument and make my own determination, or can y'all agree that, hey, you know, the law, regardless of us arguing our various sides, the law probably is this and we're okay with that ruling?
We believe
That's
out of them, we believe, and I'm sorry, Your Honor.
Go ahead.
Out of them, we believe that there might only be two that we think may need to be re-argued.
Okay.
I just want to, we don't think there's many, at least from
Okay.
the state's
All
perspective.
right, that's good.
Your Honor, I'm speaking for myself. Yesterday, we received a transcript that was a transcript of an ex parte meeting that occurred on Friday.
Right, this is the
Before
one.
the Monday.
Sorry, just to, I'm
Yes.
sorry, just so that we're clear for the record purposes. This is the transcript I gave y'all at the end of yesterday that reflects Ms. Love had said, oh, yeah, we had, and in court on the record, but ex parte discussion that led to the Monday, June 10th ex parte. So that's what you're talking about?
Let me be more artful, yes.
Okay.
We were made aware, leading to the recusal of Judge Glanville, that there was an ex parte meeting that occurred on June 10th, Monday, June 10th. We were not told by the state, we're not told by the judge that that had occurred. We found out about it, luckily, and by happenstance. We then demanded a transcript. We complained about said ex parte, inappropriate ex parte meeting. At no point, when the court finally acknowledged that there was an ex parte meeting that occurred on Monday, June 10th, at no point did the court or the state at that point acknowledge, oh, by the way, there was another ex parte meeting that occurred on June 7th. We sat there after finding out about one ex parte meeting and having to drag the truth out. We sat there, and the state and their co-conspirator, the trial court, were silent about the first ex parte meeting that happened on June 7th. What happened in that meeting on June 7th? The state went in and disparaged defense counsel. The state, with no one else there, trashed a fellow member of the bar, Mr. Melnick, trashed another fellow member of the bar, Caleb Bumpus, presumed the guilt of all these individuals, including my client, Shannon Stillwell, and all but accused myself and Mr. Steele of being co-conspirators in this YSL enterprise. And the judge agreed. And the judge said in this ex parte meeting, yes, I've observed these things. The judge presumed the guilt of all the defendants. The judge presumed the guilt of myself and co-counsel, Mr. Steele. And all this, people have been saying to me throughout this whole trial, why does Judge Glanville have it out for you? And it never made sense. And I don't assume bad motives of anyone. Why did Judge Glanville, when you did nothing wrong, try to throw you in jail? accuse you of cussing him out in open court when you didn't do anything? Why does he always tell you to sit down and be quiet? Why does he cut you off at every opportunity? Why did he try to throw Brian Steele in jail for 20 days for doing what was right? And I didn't have an answer. And then yesterday I I appreciate that, Judge. I appreciate someone finally being open about what's going on here. And I received a transcript. And in that transcript, the trial judge, who's not only assuming the guilt of my client, but is me and my friend Neil. But it's all starting to make sense. It clicked when I read that transcript last night. This is nothing, gentlemen, judge. I am going to be a partial judge, but reality, Judge, is that they don't have a right after 9 months or whatever it is. They have the right to a fair and impartial judge from the beginning. And this is absolutely gross and disgusting. And the bottom is there's a lot of discussions that need to be had about this. But the bottom line is, if you ask, is it the rulings of the judge who sits in? Yes, the judge that said and on Monday, but if we need to talk during the weekend, yeah, just handing Mr. Copeland a list of questions.
All right.
Do we need to revisit those rulings? Absolutely, we need to revisit those rulings. We need to revisit everything. This is broken, and it's not okay. It's offensive. And it's not your fault, Judge. You didn't do this. I'm not trying to raise my voice at you. I'm heated right now.
I can tell.
My head steam's been coming off my bald head all night. Nothing about this is okay. Yes, we need to revisit everything. That's my stance.
Okay, thank you. And I think that I understand you being upset, and I understand why you and probably some of your fellow defense counsel on this side of the room are upset. I do not think that everything you said is a fair characterization of what that June 7th transcript reflects. But once we have the official copy, that'll be made a part of the record, and that will show what actually happened, what actually was said. As to any kind of legal error that may have been made with regard to rulings prior to Mr. Copeland's testimony, assuming this case goes forward and assuming there is any kind of conviction, I then assumed that there will be a motion for new trial phase, which at that point I can appropriately revisit things, and then potentially an appeal, at which point those things can be raised. I am considering and reading what y'all gave me yesterday to make a ruling on the substantive matters of that ex parte, and I can consider the June 7th ex parte as well, because I suspect y'all will ask me to do that. And if I determine that that is such, that there was coercion that is unconstitutional or structural error, then I will grant a mistrial. If not, then the case will move forward and we can consider again all of the evidentiary rulings with regard to the videos and audios that might be used with Mr. Copeland, because that's the witness that we are on the stand with right now. I would, and I know this is hard to do, but I would like for everybody to try to take some deep breaths and move forward professionally. A lot of what y'all are talking about doesn't make it any easier, but it happened a month ago. I know tempers flared all around, but we need to move forward with this in whatever way it's going to move forward in a calm and professional manner, okay? So then with regard to what we need to do evidentially, I guess I will need to hear from the state as to what y'all think it's very likely for you to be using while you're examining Mr. Copeland, and then I will entertain evidentiary objections, responses, and we'll consider what's coming in.
Thank you, Your Honor. And we're getting that ready as we speak to present to the court. And I'd also like to thank Your Honor for the reminder regarding professionalism. I was going to ask that the court require that we all adhere to that. Being called co-conspirators is not something that I would expect to have heard, no more than I would expect to level an assertion that Mr. Sharp is a defendant. So I'd ask that that all sides be required to adhere to the court's admonition.
Okay, well, again, the transcript will reflect what was actually said in there, and there are some allegations that if I were an attorney and it were leveled against me, I mean, I am an attorney, but you know what I mean, practicing in a case, I would be a little hot under the collar as well. Y'all had potentially legitimate concerns. I don't honestly at this point right now need to rehash all of that. But the reminder is to everybody, okay? And I mean, I've said it, so let's act accordingly.
Ron,
Yes, sir.
if I can address the court briefly. I filed a supplement to the Mr. Kendrick's motion for a mistrial this morning. I just want to make sure the court's aware of it.
I am aware of it. I have not yet had a chance to look at it, but that's got it.
Thank you, Your Honor. Mostly I want to make sure I bring it to the court's attention because again, and I've followed the request of the court to not argue what's already in the papers, but I just want to make sure that the court understands that based on this additional information that we learned about the July 7th meeting, that my client has been consistently denied his right to a fair tribunal. It's been a due process violation. I, like Mr. Sharp, am extremely upset having read that transcript. Myself and my fellow outside agitators over here, I assume that they are upset as well. And
I don't think, honestly, I don't think that reference was to anybody who is a member of the bar. I think that there have been times in this case where members of the public are in the courtroom, which they are, of course, entitled to be, but communicating in ways that are not appropriate.
well, you know, the problem, Your Honor, is that since this was an ex parte meeting that should probably have never taken place, you were not there, I was not there, my fellow outside agitators weren't there, we don't have a video of it, so I have no idea specifically if that was not referred to us. We don't know, do we? We don't know. And what I do know is that I have been arguing with people for 18 months that Chief Judge Glanville was doing his best, that he was trying to rule to the best of his ability based on the evidence and the law before him. And now I have been made to look like an idiot. So I do not believe that this trial should continue, Your Honor.
I understand. Thank you. I'll take your supplement under consideration. Like I say, I haven't, obviously you just filed it and I haven't had a chance to look And you know, I don't know that everybody's not going to want to come up here and do their of how outraged. I feel like you need to get it off your chest. Come on, now's the time.
Okay, I got one more thing to say there. And then I'll sit down.
Okay.
And I don't believe that this is performative outrage, Your Honor.
I mean, I don't either.
Okay.
I don't either. I already said I understand.
In July of months of me complaining about late discovery from the state, which should have been produced in December of 2022, when another terabyte or so tranche of discovery was produced to us, I begged Chief Judge Glanville to put a hard deadline on the discovery being produced from the state. He refused to do so. And you know what Judge Glanville's response to me was? When I will tell you. I will tell you what his response was. If this was a civil trial, I would keep this out. But since this is a criminal trial, coming in. If this was a civil trial, if it was about money, I would keep it out. But since it's only about Mr. Kendrick's life, that last part obviously wasn't in there. But if this is a civil trial, I would keep it out. I've been a civil litigator for 25 years. I agree that if it was a civil trial, it would be kept out. What I'm shocked by, and I'm new to criminal, what I'm shocked by is that the standard would not be higher in a criminal trial. But what did I say to people? Chief Judge Glanville is doing his best. He is doing his best. And now, again, I don't even know what to say to my client, Your Honor.
All right. Well,
What do I say?
I don't know. Obviously, I don't know what to say right now either. But I think that, while again, I understand frustration, let's be careful about disparaging a respected judge. I do think that he has, and I haven't looked at every transcript yet because they haven't all been produced yet, but I don't think you're wrong that he has been trying his best and doing his best. And, we all as lawyers know that everybody talks about lawyers trying to herd cats, and that's not inaccurate. This is a big case. There are a lot of good litigators on this case, but with a lot of good litigators probably comes a lot of egos as well. And I think sometimes it is possible to sort of get so enamored of your position and of winning a point that you are focused more on that than on backing down and taking a breath and being amenable to hear what the other side is saying. And hell, that's true in our whole society right now. Should have said hell, but y'all, I mean,
You're
all
right.
right.
Those were not my words. Those were Chief Judge Glanville's words. If this was a civil trial.
Well, I don't know why it was. I don't know what evidence you were talking about. I'm sure there have been evidentiary rulings that have been frustrating to both sides. I will look at the two transcripts and I will make a ruling. And again,
Your one smart shop for back to school. More fashion, bigger savings. JCPenney, make it count.
that to the extent that Mr. Copeland said, yes, I said every one of those things to police officers, but every one of them was a lie. That is an admission that he made the statements. And the defense position, as I understand it, is as long as he acknowledges the statement, then nothing else is a prior inconsistent statement. And I'll hear from the state with regard to that, but
I add one thing. Just another layer of that. Oh, I'm sorry.
go ahead.
Just another layer of that is that the issue, the subject matter of these statements is largely the alleged co-conspirator statements, that our stance is that those were not in furtherance of conspiracy either. So
Okay.
there's like two layers
Sure.
of analysis.
Okay, thank you.
I'm sorry for interrupting.
You asked, I let you. But anyway, with regard to, does that make something said that is inconsistent in a prior inconsistent statement? And the state can provide me the law on that. But I think there are times when either an I don't remember or an I don't know or a, well, that was a lie, can still form the basis of making something a prior inconsistent statement. So, but
And Your Honor, I'm going to let Ms. Hilton speak specifically as to the law on actually what Mr. Copeland did say. What he said was, I don't remember anything that I told the police. I keep telling you, I don't remember anything. But if they say I said it, then I said it.
yeah, I think what they're talking about is he also at certain points said, yeah, I absolutely said that, and it was a flat out lie, and I'm paraphrasing, but
Okay.
that is what they're talking about, correct?
If that's what they're talking about.
Is that what y'all are talking about, Mr. Sharp, Mr. Steele? Yeah, so that's what I would like for y'all to address.
Your Honor, we believe based on two positions, OCGA 24-6-621, which be impeachment by contradiction, as well as a prior inconsistent statement, in both that statement, I said all that I said, but it was a lie, or I was trying to finesse my way out of being locked up, would lay the grounds of still allowing the prior inconsistent statement to come in.
Okay, and the 24-6-621 is the
Impeachment.
by contradiction, and 24-6-613 is essentially prior statements, right?
Yes, Your Honor.
So what I'd like is some case law that represents the proposition that you are asserting, okay?
Yes, Your Honor.
All right. And I don't want it just simply quoted out of a horn book. I would like the actual case law.
Your Honor, if you can give us a moment,
Okay.
we need to.
I mean, y'all, when I told you a week and a half ago that I wanted to be going through Mr. Copeland's evidence, y'all had 10 days or more to get ready for this. So I don't know what y'all thought we were going to be doing, but yes, I'd like to hear it. So if you need a minute to give me the law, go ahead. Is there, we can also do this portion after lunch and do something else right now, because I don't know that we all need to sit in court and do our research. What else could we do that's productive?
Your Honor,
Yes.
I would like to make records. The Honorable Attorney John Melnick is under subpoena. He's in your courthouse, to my knowledge, or to my belief.
Okay.
If your court thinks that's a good use of time, he is going to, I believe, take to task the statements of Lawyer Love.
All right. Well, tell me why that matters, because what may have been the actual truth and what Miss Love and or Miss Hilton perceived and therefore caused them to want to speak to the court ex parte don't really have to be the same thing. And I don't know that it matters whether what they thought was true was actually true.
So objectively, he will go through the emails for the court that were misrepresented by Lawyer Love. I'm making a record, God forbid there's an appeal as well as for your consideration in this case going forward about calling Judge Glanville as a witness. that, he spoke with Lawyer Love. She knew that he represented Mr. Copeland. Lawyer Love said that she did not know that he had denied representing him, Mr. Copeland.
That Mr. Copeland had denied that Mr. Melnick represented him.
No, Lawyer Love stated that John Melnick had previously denied representing Mr. Copeland to Judge Glanville. And that goes to the heart of why is there a ex parte meeting in the first place? Because I don't know why there was, but Judge Krause I've objected to it. And I know you said maybe not, it's dicta, and I agree that did not go to the holding or the ruling. And she didn't make long statements of fact or findings of fact. So I appreciate you saying, I don't know if these are findings of fact, but maybe just surplusage. But if that meeting is the way Judge Krause found, and there is a honorable Superior Court judge who made that ruling that's cemented in our case, that, I forget the line, but something like maybe it should have been done in open court, but the substance proper, something to that effect. If it was done in open court, I would have been able to be there to question Mr. Copeland. I would have been able to be, because the Judge Glanville said, you have questions for your lawyer, the state, or me? If I was there, I assume he would have said, or Mr. Steele. And then people were asking him questions. They were discussing his testimony. Those are things that we had a material right to be present for. So the point I'm trying to make.
Okay, well, I'm going to make a substantive ruling with regard to that, and I don't know how Mr. Melnick is going to add to that. I mean, it is clear to me from reading that June 7th transcript that the questions they had about whether Mr. Melnick represented Mr. Copeland were not, is he literally counsel for Mr. Copeland right now? I mean, they knew he was that because Ms. Hilton said when Mr. Copeland asked to talk to Ms. Hilton outside of the courtroom, and they were about to talk, Mr. Melnick either was there or appeared, and Ms. Hilton said, oh, you seem to want to talk to him, so I will let y'all talk privately, which if she didn't think Mr. Melnick were representing Mr. Copeland, wouldn't have done. I mean, there would have been no reason for her to do that. I think that it is clear in context that what they meant by we've got questions about whether he's representing Mr. Copeland is, and they said it, we have questions about whether he is representing Mr. Copeland's best interest, which as a lawyer, you are always supposed to do for your client. So I don't think they meant literally has he entered an appearance for Mr. Copeland, or has he represented to us and to the outside world that he is counsel for Mr. Copeland? It was, is he really acting in the best interest of Mr. Copeland? That's what they said they wanted to research and then meet with, or potentially meet with Judge Glanville about.
On the 10th, Lawyer Love said John Melnick, the Honorable John Melnick, stated that he was not representing Mr. Copeland. And Mr. Melnick said that is just a flat out misrepresentation of conversation.
Okay, well.
So I just want to get the record straight, because Georgia law, and I gave you these cases in a footnote, Georgia law right now, and I know I'm very familiar with this Honorable Court's very in-depth knowledge of the law. So right now, it's if the court finds, this court finds, or an appellate court, that Mr. Williams et al. Had a right to be present, that's at a critical stage of proceeding, it's over. The case, no one looks at prejudice. But the two cases that came out in April, one of them may have been in January, but I cited them in the footnote of my motion to just educate the court.
Well, if it's there,
I could give it to him, but yes, it's
that's
there.
fine, I'll jot it down.
But the Georgia courts are saying that is the law now, but we are interested in whether that is wrong.
Okay.
And we need to show prejudice.
Okay. With regard to,
Like federal.
give me the cases in what?
Step back.
Okay.
But so I want to make a record of showing it was prejudicial because they were knowing misrepresentations to even have a auspices of a meeting with the judge.
Okay, well,
And I'm not agreeing.
I'm not sure if I follow you though, with regard to, I need to establish that Mr. Melnick was in fact counsel for Mr. Copeland, because even in the June 10th ex parte meeting, Ms. Bumpus was there as stand-in counsel for Mr. Melnick, because apparently Mr. Melnick had said he had a pre-scheduled vacation or something like that, which everybody knew about on Friday or before Friday. And they were saying, you know, how can he actually be representing him, i.e. the best interest, if he's off on vacation when this critically important thing for Mr. Copeland is going on. But here's his standing counsel, Ms. Bumpus. So they understood that technically, at least, Mr. Melnick was representing Mr. Copeland. So, I mean, that's, I can take judicial notice of that to the extent I need to.
I'm inarticulate then, because Mr. Melnick, I believe, is going to have testimony before your court for you to judge credibility.
Okay.
That what was said out of the mouth of the two prosecutors, Hilton, Love, are not true. There's no emails to back up what Love says. Ms. Hilton, there's not this Mr. Copeland, I need to speak with the DA. Those things have been unrebutted. They're just being said. And my point is, without that, then why are you questioning another lawyer's ethical duties? What gives you the right to say that to the judge? And then the courts need to know that's not true.
All right. Just like I said to the state essentially yesterday with regard to their motion that suggested that defense attorneys were violating bar rules in the way that they talked to the press, I am going to suggest to the defense that if the state is violating bar rule, or attorneys for the state are violating bar rules in the way that they talk about defense attorneys or in representations that they make to the court, that too is something that they may have to deal with the state bar.
I understand, but I'm dealing with, my concern is Mr. Williams. So I'd like you to make findings, because I think that they go to the heart of, you're entitled to ethical prosecutors. We demand that. Ethical lawyers, ethical prosecutors, and a fair tribunal. That's constitutional, as a fair tribunal. That did not happen here in my advocacy, in my viewpoint, the way I understand what happened. I wasn't there. So I can't talk about, I wasn't in the outside the courtroom when this supposed Mr. Copeland wants to talk with Ms. Hilton. I don't know. All I know is what we do. We come in after the fact, we investigate. Mm-hmm. But I'd like to spread that on the minutes. So I raised that. I don't know, Mr. Melnick's day-to-day or.
I don't know that.
But I'd like to call him.
I understand. And I don't know that that is ultimately relevant to the determinations I have to make, because again, whether what the prosecutors represented to Judge Glanville was true or not, maybe an issue for another type of tribunal. But in terms of whether it was then appropriate for Judge Glanville to okay the June 10th meeting to further flesh that out is what I need to figure out, right? So it doesn't really matter whether what they said was true for that purpose. It is, they told Judge Glanville what they told Judge Glanville. Was it reasonable at that point for Judge Glanville to entertain the ex parte on Monday, the 10th? Okay. So let me make that determination.
I'd like to call him if you change your ruling. Both Judge Glanville.
You can proffer what he would testify to.
And I need to, because he didn't see this new transcript, so I need to, he being Mr. Melnick.
Well, what's in the transcript shouldn't influence what's true. So
I would think, no, it doesn't. I would think that he can then say, or tell me and I'll tell you, and then you can hear from him if you want, that did not happen or this. I want to get it right.
All right. So you haven't talked to him yet about what? All right. Well, obviously I'll give you a chance to talk to him before you make a proffer, because you need the proffer to be accurate.
Okay.
All right. So that's not something we can do right now either.
Okay. Thank you.
All right. So what can we do? And if there's nothing, then I'll just go back in chambers and I'll read all my cases that y'all gave me yesterday and I'll make some rulings so I can still be productive and y'all can be productive out here. You want to break for an hour and a half? Okay.
Thank you.
All right, let's come back at 11.
Does the court mind that we stay here?
Doesn't matter to me. Deputies, so if that's fine, but I'm not going to ask them to stay here. They've got a lot of other work to do too. Okay. About.
On the 10th, Lawyer Love said, John Melnick, the Honorable John Melnick, stated that he was not representing Mr. Copeland. And Mr. Melnick said that is just a flat out misrepresentation of conversation.
Okay, well,
Melnick
I
is
just
in
want
the
to get
court.
the record straight because Georgia law, and I gave you these cases in a footnote, Georgia law right now, and I know I'm very familiar with this honorable court's very in-depth knowledge of the law. So right now, it's if the court finds, this court finds, or an appellate court that Mr. Williams et al. Had a right to be present, that's at a critical stage of proceeding. It's over. The case, no one looks at prejudice. But the two cases that came out in April, one of them had been in January, but I cited them in the footnote of my motion to just educate
Okay,
the court.
well, if it's there,
I could give it to him, but yes, it's
that's
there.
fine, I'll jot it down.
But the Georgia courts are saying that is the law now, but we are interested in whether that is wrong,
Okay,
and we need to show prejudice,
okay. With regard to,
like federal.
give me the cases in what
Step back.
okay.
But so I want to make a record of showing it was prejudicial because there were knowing misrepresentations to even have a auspices of a meeting with the judge.
Okay, well,
And I'm not agreeing.
I'm not sure if I know with regard to, I need to establish that Mr. Melnick was in fact counsel for Mr. Copeland, because even in the June 10th ex parte meeting, Ms. Bumpus was there as stand-in counsel for Mr. Melnick, because apparently Mr. Melnick had said he had a pre-scheduled vacation or something like that, which everybody knew about on Friday or before Friday. And they were saying, you know, how can he actually be representing him, i.e. the best interest, if he's off on vacation when this critically important thing for Mr. Copeland is going on. But here's his standing counsel, Ms. Bumpus. So they understood that technically, at least, Mr. Melnick was representing Mr. Copeland. So, I mean, that's, I can take judicial notice of that to the extent I need to.
I'm inarticulate then, because Mr. Melnick, I believe, is going to have testimony before your court for you to judge credibility.
Okay.
That what was said out of the mouth of the two prosecutors, Hilton, Love, are not true. There's no emails to back up what Love says. Ms. Hilton, there is not this Mr. Copeland, I need to speak with the DA. Those things have been unrebutted. They're just being said. And my point is, without that, then why are you questioning another lawyer's ethical duties? What gives you the right to say that to the judge? And then the courts need to know that's not true.
All right. Just like I said to the state essentially yesterday with regard to their motion that suggested that defense attorneys were violating bar rules in the way that they talk to the press, I am going to suggest to the defense that if the state is violating bar rules, or attorneys for the state are violating bar rules in the way that they talk about defense attorneys or in representations that they make to the court, that too is something that they may have to deal with the state bar.
I understand, but I'm dealing with, my concern is Mr. Williams. So I'd like you to make findings, because I think that they go to the heart of, you're entitled to ethical prosecutors. We demand ethical lawyers, ethical prosecutors, and a fair tribunal. That's constitutional, a fair tribunal. That did not happen here. In my advocacy, in my viewpoint, the way I understand what happened, I wasn't there. So I can't talk about, I wasn't in the outside of the courtroom when this supposed Mr. Copeland wants to talk with Ms. Hilton. I don't know. All I know is what, we do. We come in after the fact, we investigate. But I'd like to spread that on the minutes. So I raised that. I don't know, Mr. Melnick's day-to-day or.
I don't know that.
But I'd like to call him.
I understand. And I don't know that that is ultimately relevant to the determinations I have to make, because again, whether what the prosecutors represented to Judge Glanville was true or not, maybe an issue for another type of tribunal. But in terms of whether it was then appropriate for Judge Glanville to okay the June 10th meeting to further flesh that out, is what I need to figure out, right? So it doesn't really matter whether what they said was true for that purpose. It is, they told Judge Glanville what they told Judge Glanville. Was it reasonable at that point for Judge Glanville to entertain the ex parte on Monday, the 10th?
Okay.
Okay, so let me make that determination.
I'd like to call him if you change your ruling. Both of them, Judge Glanville.
You can proffer what he would testify to.
Then I need to, because he didn't see this new transcript, so I need to, he being Mr. Melnick.
Well, what's in the transcript shouldn't influence what's true. So
I would think, no, it doesn't. I would think that he can then say, or tell me and I'll tell you, and then you can hear from him if you want, that did not happen or this. I want to get it right.
all right, so you haven't talked to him yet about what? All right, well, obviously, I'll give you a chance to talk to him before you make a proffer because you need the proffer to be accurate.
Okay.
All right, so that's not something we can do right now either.
Okay. Thank you.
All right,
And what you saw there,
So,
guys, just to interrupt.
what can we do?
Brian Steele is on a mission, and he wants to have Jeffrey Williams, aka Young Thug, aka King Slime, found not guilty. But he has another mission. He has another mission. Brian Steele wants to interrogate Judge Glanville on the stand. And you saw back then, just right there, a little jockeying. He's like, no, I really need to get him on the stand. This judge does not want to let Glanville on the stand. And so she said a lot of that yesterday. It was a lot of going back and forth. This is a big fight because Brian Steele wants two things out of this trial. He wants an acquittal, and he wants to have Glanville, Love, and Hyatt on that witness stand. And so you saw a little jockeying there about that.
And if there's nothing, then I'll just go back in chambers and I'll read all my cases that y'all gave me yesterday and I'll make some rulings so I can still be productive and y'all can be productive out here. You want to break for an hour and a half? Okay. All right, let's come back at 11.
All right, because they are going to come back at 11. We are going to read the transcript that
Doesn't matter to me.
AV has gotten for us. It's like the judge took a break so we could read the transcript. Guys, this is amazing. Absolutely. Hold up. Let's are they going back on? Hold up. What are they talking about? They faked us out. Oh my goodness. All right. So the court is on break until 11. I forgot, guys, that what time is it now?
9:43.
9:43. So we got some time.
We got TiVo time, so that's good.
Yeah, because that's what I was looking at.
Here's the thing, aging begins in your cells. Start supporting your cell health today.
DigiCert Trust Lifecycle Manager helps you do what your organization needs PKI to do. Prevent outages, manage risk, and enforce policy. That's digital trust for the real world.
T Jetty. Miss Crow T Jetty, get them 5 subs, and thank y'all for shouting her out. The ones who were who received those subs, and also full dunking and half thinking, full drinking and half thinking. It's too early for me, guys. All right, so what we're gonna do is pull up, and we're gonna read some more super chats. And if y'all want to support AV, there is her Cash App right there down at the bottom. I am going to pull up the transcript that AV has gotten. Ooh, I was hoping it was a, what them girls say, I was hoping it was a little long. Pause. This is 19 pages, so this is going to help us.
Yeah, just for some context, guys, this was filed this morning, and you did hear Doug Weinstein say that he filed a motion this morning. He actually added it as Exhibit A. So at 7:15 a.m., and I want to give a huge shout out to Danielle, who got her hands on this and sent it to me. Danielle is the best.
Danielle is amazing, absolutely amazing. So let's see what we got right here. And shout out to Candace, the beautiful Candace Yates, always supporting me, always supporting AV, always supporting the community. She says, good morning, AV and Lee. Nice to see y'all just tuning in. It's judiciary already, right? It is crazy. How do you say that?
Ciao, boo.
Charlie Boo.
Charlie boo. We tried, Candy. We tried.
Right. All right. So let's see what this dang transcript. Somebody write transcript. Oh my God. And these judges are so hot. They are so pissed off at this transcript. What the hell is in it? We are going to find out. So as the AV said, this was just filed today. It was filed at 7:15 in the morning, crack of dawn and early yawning. Wipe the coal out my eye. All right, now, in the Superior Court of Fulton County, State of Georgia versus Diamante Kendrick. So is the transcript attached to this?
Yes, it's Exhibit A. So
All
about
right.
2 pages in.
All right. So let's read the transcript first.
There it is.
Let's read the transcript first. All righty. So y'all ready? Now, guys, just to put some sauce on it, just to be clear, this is not the transcript of the Monday Kayla Bumpus Mole secret meeting that we all heard about. Well, what are we about to look at, AV? What is this?
This is a second secret meeting that took place the previous Friday, June 7th. This is why Max started the day like pissed off because he's like, what the hell? There was a second meeting, and Judge Whitaker, like, she is the one that made this available to them last night. So they didn't even know it existed.
Yes, no one knew. No one knew. So let's see what the hell is going on. Can y'all see it? I know it's it's a little light. All right. So do you want to read this? Everybody loved your renditions of these transcripts.
Oh yeah, of course. Whenever there's a little Woody voice, I got y'all. All right, Miss Love. Judge, the reason that I specifically wanted to talk with you is that I have a concern about the representation being made of the representation of Little Woody. I am concerned, and I'm sort of not, I want to just bring it to the court's attention. Mr. Melnick has not conveyed to either Ms. Hilton, myself, or any member of the state any legitimate concern that he has regarding Little Woody testifying. What we have seen is physical interactions with persons besides Little Woody, that would indicate that Little Woody is not Mr. Melnick's primary priority.
Let's stop it right there. That's a huge thing. The state is saying that Mr. Melnick's client is not Mr. Melnick's primary priority. And that's a huge slap in the face. That's very disrespectful to say to an attorney. All right, you want to pick it up right here?
Yep. What we do know is that when the fact that he's willing and wanting to leave and leave number one, he left twice after the court ordered him to speak with his client. And it would seem his actions convey that it is not Little Woody. It's not in Little Woody's best interest that is his priority. Ms. Hilton was out speaking with Little Woody at Little Woody's request at the time that I announced that Ms. Hilton was calling Little Woody. What I did not know is that she was trying to tell you to give us a minute because Little Woody was feverishly, and I'll let her speak as to how that went down, feverishly trying to get her in there to convey to her something that Mr. Melnick had just said to him that did not come from any of us.
Okay, so that was Miss Love, I suppose. Is that right? And now we're about to, Miss Love is saying, hey, I'm going to let Miss Hilton tell you what the deal is, Judge. So then the court said, well, what was that, Miss Hilton? All right, you want to pick it up right here?
Ms. Hilton says, so let me just put the order of operation. I got up because Deputy Chief Long said he wants to talk to you. Come out right now. So when I went into the room, Melnick either came in or came outside. And what Little Woody said, and I think what he wanted to get some autonomy, I want to talk to you. He's like, I've already talked to you, but I want to talk to her. And Mr. Melnick kept like blocking him being able to talk to me. So eventually I was like, well, clearly you want to talk to him. So I'll step out and you can come in. Mr. Melnick spoke to him, and I think he was trying to eat up time because he knew that you were coming out. Oh my God. So by the time I got back in there and he started to talk, that is when everyone said, come on, the judge is waiting. And that's why he stormed in angry. Miss Love, he being Little Woody, Miss Hilton, because I think he was trying to convey to me some concerns he had. And so I was just trying to have that conversation because Little Woody and I have been having really good conversations since Friday, like very, very good conversations. Just not even about the facts of the case, but just life experiences. So I think I was building rapport with him such that he thought I lied to him. So I was trying to explain to him, Miss Love, and by that she means today, Miss Hilton, today what was going to happen, Miss Love, because of what someone conveyed to him. Miss Hilton, we believe that something was being conveyed. What happened is as Little Woody was walking back into the courtroom, Mr. Melnick and Julie would have to, Miss Linsaqua would have to confirm this, but he said they are going to hammer you. And that made me ask Miss Love, did you say something about hammering him? And I don't know who, Miss Love. Nobody did. The court. It doesn't make, oh, this is Glanville. It doesn't make sense you would say that to him. Miss Love, we never said that. Glanville. But anyways, okay. Miss Hilton, so whatever that communication was, that's when he stormed in and got angry. And as the result, I don't know, I think they made a mistake here. I got was what he gave when we started. So at this point, I'm very concerned. Miss Love, he meaning Mr. Copeland stormed in and got angry.
Okay, so Little Woody storming in and getting hot. Let's go.
Miss Hilton said the timing of everything is very ironic. We laid it out on the record earlier about what happened. And I don't believe that Mr. Copeland's best interest is being served at this moment, given that, Mr. Melnick was willing to take a vacation and let him languish in jail. And that is not, we have communicated that we never want Little Woody to go to jail. We don't want him in custody. We don't want any of that to occur. And so, Miss Love, and Mr. Melnick has not spoken. He has not relayed. What we did get during the break was an email from Mr. Melnick. I don't know if he had to have been blind copying someone else. The only two people I could see on the email were myself and Miss Hilton. But he referred to me in the third person and said, these are the communications between myself and Miss Love. So I asked Mr. Melnick, whose interests are you concerned about? Your clients or Mr. Steele's and Mr. Sharp's? But prior to, and this is not the first time Little Woody has said, he doesn't represent me. This is not the first time Mr. Melnick has, and let me be real clear. When we spoke of what was happening before, he representing Little Woody and da-da-da-da-da, he told me that he didn't represent Little Woody. He told me, Glanville, Mr. Melnick told you? Miss Love, yes, Mr. Melnick told me previously that he wasn't representing him. Glanville, you would not speak to an unrepresented party. I know you know enough of the rules to know that if you thought or intimidated that somebody was represented by counsel, you would go ahead and let them contact that lawyer. Miss Hilton, or Mr. Copeland would have said, because I don't know as a witness, because he is not charged, if we would have had to, Miss Love, right. Miss Hilton, because he's not charged. Glanville, I don't think you have to because there's no pending charges. But if he told you, I got a lawyer, I don't want to talk to you, Miss Love, we would have left. Glanville, because people counsel that they have under retainer or something else, or they say, hey, I got a lawyer that I use for everything and I want to talk to him. I don't feel I'm not comfortable talking to you unless my lawyer is present. Miss Hilton, we have done that with a number of our witnesses here. So this would have actually been no different, Miss Love. Exactly. And we would have had, I'm sorry, I don't mean to cut you off, Miss Hilton. No. Go ahead. That was it. Miss Love, we actually communicate, especially when either they are incarcerated or subject to having their sentence revoked as a result of their testimony because they pled guilty here. Because that's the best way, in our opinion, to get rapport that elicits truthful testimony. So in this particular instance, there was not that number one. There was not that communication made by Little Woody that there was ever a need for that. And two, there was not a need for us to be concerned about it because he doesn't have charges. Ms. Hilton explained that to him at length, that whatever happened that he did in 2015, which is all we're going to be talking to him about, the statute of limitations has run. He didn't do the murder. We know that.
I did these crimes.
I mean, so I don't know. I don't want to get into the facts of anything. What I'm trying to get at is the fact that Little Woody, I don't believe, I believe Mr. Melnick has inserted himself in a way that jeopardizes the best interest of our witness. I believe that in conveying to the court that Ms. Bumpus is going to stand on his stead. Ms. Bumpus she was, what is the word I'm looking for? The sheriff had to speak to her because she was in the courtroom trying to hug Jeffrey Williams.
Wait.
What's Kayla doing?
Kayla over there trying to hug King Slime? Jesus Christ.
Well, she knows their family. She's had them on her channel.
Oh, wait, she's had King Slime on the channel?
Members of his family.
Oh, members of his family? Wow. All right, let's keep it going.
Miss Hilton, no, she hugged Diamante Kendrick. Miss Love, I'm sorry.
Oh, well, shit, that's how rumors get started. All right. Next thing you know, Kayla and King Slime are fucking. All right, that's how rumors get started. All right.
Too funny.
Shout out to Attorney Hilton, or Attorney Love.
Miss Hilton, in fact, she hugged Diamante Kendrick and hugged Mr. Williams. And that's how Captain Kendall saw her. And Captain Kendall had her taken out. Miss Love, she expressed dismay and concern in challenging her right to go to interact in that manner with the defendants. So our concern is that it is not Little Woody's best interests that are being represented. And not only is that the case with respect to Little Woody, but who we have no interest in prosecuting. But there is a tampering of sorts going on in this person inserting himself, where Little Woody has been reaching out to speak to Miss Hilton, and that communication is being blocked by someone Little Woody didn't reach out to.
Okay, so what they're saying is Melnick is inserting himself in this case. Melnick represents Woody, and that's the contention. But what's the problem? The problem is the state needs Little Woody. If they need anybody else, they need Little Woody. And so the state sees that someone is interfering with their relationship. They want to be able to get Little Woody and to talk to Little Woody as much as they want. But Melnick is like, hey, I represent him. Don't come around here. And they need to talk to Little Woody to get their story straight. And so what they're saying now is, hey, someone is doing, and notice the word right here, tampering. And because we know about that witness tampering, but there is a tampering of sorts going on in this person inserting himself, Melnick, where Little Woody has been reaching out to speak to Miss Hilton, and that communication is being blocked by someone, aka Melnick, Little Woody didn't reach out to. All right, so they're trying to remove this obstacle that Melnick is representing. But they need full access to Little Woody, and Melnick is getting in the way. All right, you want to pick it up right here?
Yep. You notice no one said, Mr. Copeland called me. He never.
Let me just jump in. Me and AV were saying Woody, but technically it's Woody. So
Woody, sorry.
Shout out to little Woody. We'll try to remember it. Shout out
Woody.
Shout out to Woody.
Okay, notice no one said, Woody called me. He never said, when he put on the record, when Miss Hilton said, the way I understand it, Mr. Melnick reached out to Woody because the first time we heard an assertion like, oh, he's going to plead the fifth, is when Mr. Melnick sent an email to Ms. Hilton and myself and copied on it Mr. Steele and Mr. Shard last night. Glanville, why would he have given Ms. Hilton? And that's the state's concern. Ms. Love, that's the point. Glanville, but here is the challenge. The challenge is you have privileged communications, and unless you've got him being the client, disclosing to a third party that you wouldn't be subject to privilege. That is the only way you're going to, Miss Love. I don't disagree with that at all. I don't disagree with that at all. But if Mr. Melnick, and the thing that's got me the most is Mr. Melnick is not looking at Mr. Copeland saying, you know, Woody, I want you to stay out of jail and I will be here with you. And if they ask you anything that touches upon something that you and I talked about, I will stand up and assert your right. He didn't do that. What he did was he looked over at two people and said, like, I did what I could, shrugged his shoulders, held up the palms of his hands like this as to say, I tried.
I tried. And we tried, speaking of try, we tried to go back and find the shoulder shrug, but we couldn't.
We did. There is no reason he would be looking to the right to counsel for the defense like I tried after Mr. Copeland said he was going to testify. That doesn't make sense.
All right. So right there, what they're saying is Melnick is in the pocket of the defense attorneys, and Melnick is blocking Woody to testify, or wanted to block Woody to testify, not to help little Woody, but to help Shannon Stillwell, to help Shannon Jackson, to help SB, to help Jeffrey Williams, Young Thug, King Slime. And what they're saying is, you know, right when Woody was about to testify, Melnick was on the stand, and Melnick just held his hands up, and he looked to Brian Steele, and he looked to Shard and said, well, I tried to stop him. And Attorney Love said, well, why would you do that? Why would you turn to the defense counsel and say, I tried to stop him? What does the defense counsel have to do with this? Why would you shrug your shoulders and say, hey, I tried to stop him? Why would you be so interested in stopping Woody to testify and turning to the defense counsel and seeking their approval, seeking their validation? Why did you need to let them know that you tried to stop him? What is y'all's relationship, Melnick and the defense counsel? That's what they're wondering. That's the argument there. All right. Want to pick it up right here?
Yep, Glanville. Well, there's a lot of innuendo that they have asserted themselves. They, being some of the defense counsel, have inserted themselves in this particular process.
Wait, I cannot believe,
Mm-hmm.
I cannot believe this judge is talking negatively, even about some of the defense counsel, without the defense counsel being there. Guys, remember, to all the new people that are showing up, this is a second secret meeting.
Mm-hmm.
The first secret meeting we found about on Friday, it just hit the wire today that there was a second secret meeting. And this is what we have the transcript for. And if y'all missed it in the beginning, these attorneys, when they showed up at court at 8:45 today, already having seen the transcript, they were hot as hell. Shard was damn near screaming in court.
Mm-hmm.
So and so we are reading right now what has these damn attorneys so hot. It seemed like they were hotter about this than they were about the last secret meeting. So we have the transcript. AV and Danielle have gotten this, and so this is what we're looking at. All right, you want to pick it up right here?
Miss Love, my concern is Mr. Melnick's insertion of himself. Glanville, what are you asking me to do? What are you asking me to do? And what do you think that I can do? Miss Love, that is the exercise. That is the homework for tonight.
The homework.
She said that to Judge Glanville.
Jesus.
I wanted to let the court know that that is what we're looking into right now, because there is a remedy, because I have faith in our law. I love this thing. And I know there is a remedy, because this can never have been the first time this happened. It has been addressed. I just have to find it. But I didn't know what to be looking for something and not let the court know what I'm looking for. So you are not, so that you are caught off guard when Monday morning or Saturday night or Saturday afternoon, we find it and send it to you. Glenville. Okay. Miss Love, so thank you for allowing us to audience with the court. I just wanted to make certain that we did it properly and we had everything on the record. It is our witness. We have conveyed to him that he is shielded from prosecution for anything that he talks about on the stand and any use of that. And the thing is, we don't want to ask him that, but this is what he said. Y'all might not, but they may ask me about some things that I have to assert my right on. And that would be a question by question basis. What he is being influenced to do, we believe, by Mr. Melnick, and it's through Mr. Melnick, because as you saw, Woody said, I will testify. Mr. Melnick, even after that, said he's asserting his fifth. I'm going to talk to him. Logically, one would think that as long as Mr. Melnick's concerns about Woody's freedom, legal freedom, and his exposure, as long as those were addressed, Mr. Melnick should be saying, I am here with you. If there is something that I know will put you in jeopardy, I will stand up and stop you. But right now, I would rather you stay out of jail. Instead, you get Mr. Copeland, and you can see through his body language, he gets there in court and he's smiling as if making a show of being taken into custody after this. And that man don't want to be in jail. He said it. Did he say he don't want to be in jail? Miss Hilton, that's his biggest fear.
Here's the thing, aging begins in your cells. Start supporting your cell health today.
Woody. Woody is the whole damn case. This case is going to take years. And Woody is the number one witness. And when they see anybody blocking their access to their number one witness, they need to snap it off, because if they don't have Woody, they don't have anything. All of this is for naught. Their reputation would take a huge hit if they lose this case. And looking like they're losing it, right? And so they were so fearful about Melnick getting in and messing up their relationship with that they have with their star witness, Lil Woody. All right, you want to pick it up right here?
Yeah. Miss Hilton, she's about to lose her mind, because her biggest concern is that Mr. Melnick is actively harming a human being. And that's what she's maddest about.
Wait. This is such bullshit. Does anybody believe that it's, and this is Love talking, Attorney Love is saying, does anybody believe that Miss Hilton is about to lose her mind because her biggest concern is that Attorney Melnick is actively harming a human being? No, that is not why Attorney Hilton is losing her mind. Attorney Hilton is about to lose her mind because her biggest concern is that Melnick is going to block the communication with her star witness.
Mm-hmm.
Her biggest concern is that Melnick is going to make her lose this trial. That's her biggest concern. That's what she's maddest about, right? Not that, Miss Hilton don't give a damn about Lil Woody. Oh, yeah, she's Mr. Melnick is harming a human being. That's bullshit.
Mm-hmm.
All right, let's pick it up. Right. And guys, they're telling this to the judge in a secret meeting.
Just the three of them.
Just the three of them. No defense attorneys. They're getting their story straight. The two attorneys and the damn judge.
Wow.
This is insane.
Back to Miss Love. I'm mad because it is stopping our trial and it's wrong. And that is not how the law is supposed to work. So we have two big, old, grave concerns that we are working to remedy right now. Glanville. Okay. Well, like I said, I think that you brought your concerns to me. You know, without more, I don't know what else I can kind of do in terms of that. My comments today were predicated on that there's a lot of stuff that's going on in the background, but it shouldn't have to do anything with you all's case. It really shouldn't. But I think it does in some way. Outside agitators.
Well, and this is what Doug Weinstein got so mad about, this outside agitators phrase.
Miss Love, that too, Glanville, and everybody else who I think are trying to influence Miss Love, that is absolutely happening. Miss Hilton, there's a lot going on. Miss Love, there is a presence. Yes, yes. That is all I'll say.
So let's stop right there. You know, when the court says, but I think it does in some way, the outside agitators and everyone else who I think are trying to influence. And this is what the attorney Love was saying, that Melnick is inserting himself and trying to influence the way that this goes. Well, the judge is saying the same thing. What's the problem? The judge is referring to Melnick, it seems. The judge is referring to attorneys, defense attorneys. The judge is not calling the prosecutors outside agitators. The judge is talking to the defense counsel or referring to the defense counsel as outside agitators. This is insanity. It's so corrupt. All right, you want to pick it up right here?
Miss Love, there is a presence. Yes, yes. That is all I'll say. Glanville, I mean, but I see it from just being in the courtroom and tracking. But okay, if you find anything, we'll see where Monday leads us. And like I said, since we now know he's going to potentially invoke, we'll see what his pleasure is. And Miss Love, I mean, just the idea of someone sitting in jail throughout this trial, but if he does, if that's what he's being counseled to do, and that's what he does, that's just wrong. It's wrong because a member of this bar is, in my mind, creating that circumstance, you know? He's going to do what the person he trusts to have his best interest at heart tells him to do. And that person, he doesn't have to tell us what he's concerned about. He can just sit there. And when he sees the train coming, stand up and say stop. But he's got a vacation to go on, so he can't be here. So Miss Bumpus is going to be here. Miss Bumpus hugging Mr. Kendrick and Mr. Williams is going to be here representing the interests of Rudy, who is supposed to testify against Mr. Kendrick and Mr. Williams. She was talking about her.
See, and she says right here, she continues, that is where we are. This doesn't pass the smell test. And so this is what they're saying. And I see why, if I'm gonna be honest, I see why they're concerned. I see where they're concerned. Imagine, guys, imagine that you need one person for the biggest case of your life. You need one person to testify, and it's little Woody. And you are an attorney yourself. So you know you can trick little Woody and you can try to play mind games. That's what you're thinking. You're thinking you're so much smarter than him. But what's the problem? An attorney has come in. And this attorney looks to be in bed with the attorneys for the defense. In fact, you think that the attorney stood up in court, and when little Woody said he might testify, the attorney shrugged, held up his hands, and looked to the defense and said, hey guys, I tried to block him for you. I tried to stop him for you. And that's the attorney for your star witness. And then on top of that, that attorney says, well, you know, I have to go on vacation, so I'm going to send another attorney in. Who is that damn attorney? It's the attorney that is hugging King Slime. Imagine you need a witness to testify against King Slime, and your witness is being represented by an attorney who is hugging King Slime. How do you think that's going to go for your case? How do you think that's going to go for your career? You need a witness, your star witness, to testify against King Slime. And the attorney that represents your star witness is hugging on King Slime, is hugging on Mr. Kendrick.
Yeah, and even taking it a step further, like they know each other. Love and Kayla worked at the prosecutor's office at the same time. So it's, we know Atlanta's small and a lot of people in the legal community know each other. They've crossed paths before. So if you're seeing that, it's interesting.
Yeah, so this is so crazy, guys. So she says this is where we are. It doesn't pass the smell test. We are worried that Kayla Bumpus is hugging Mr. Kendrick, is hugging King Slime, when we need little Woody to testify against Mr. Kendrick. We need little Woody to testify against King Slime. And now they're hugged up. Judge, help us. Help us. We need help. Judge says, all right.
Okay. He always says that. Okay.
Okay. So let's keep it going. All right. So that was the now I'll be honest. This is the transcript. We read it in full. And so there were a few things, but I'm surprised a little bit at the heat that the attorneys were taking. But now let's read the motion, because the motion is going to probably explain to us what the attorneys saw in this that has them so effing hot. All right. Let me do this so we can wait. Did I mute myself? Can you hear me?
Yeah.
Okay. All right. So what supplement to Diamante Kendrick's motion for a mistrial? This is like the 217th motion for mistrial. All right. Let's see what Diamante says. Now comes Diamante by and through undersigned counsel and shows this honorable court the following. Outside agitator is a term that delegitimizes internal dissent against the status quo. So anyone who speaks up against the status quo, whatever it is, by definition is an outsider. Professor Dillon of UC Berkeley. Judge Glanville making outrageous allegations against members of the defense team in the present case, but I think it does in some way outside agitators and everybody else who I think are trying to influence. The third ground argued in Kendrick's motion for mistrial is that Kendrick's due process rights were violated relating to the 14th Amendment due process violation, relating in part to Chief Judge Glanville's wrongly coercing Lil Woody to testify. Further evidence of the state and Judge Glanville's violation of Kendrick's due process rights has just come to light this morning. Yesterday, after court, Diamante received a rough transcript, Exhibit A, of an additional secret ex parte meeting with Judge Glanville held on Friday, June 7th. The rough transcript was helpfully provided by this court to defense counsel. A reading of the rough transcript highlights that which has been obvious to all observers except for Kendrick's attorney, except for me, Doug Weinstein, for the past 19 months. Glanville has been willfully biased and acting as a member of the prosecutorial team since the inception of this case. Diamante's counsel, me, Doug Weinstein, I take no pleasure in alerting this honorable court to this situation, but client obligations require it. Due process requires a fair trial. It is not a fair trial when in an ex parte meeting, Glanville, Love, and Hilton gossip. Like, they gossiping like Yenta. So what is a fucking Yenta?
Let's look that up. What
Somebody
is
look up Yenta. Somebody write Yenta in the damn chat. YNTAS. They're gossiping like Yentas.
Define yentas. Yenta is a woman who is a gossip or a busybody.
Oh, they're saying Glanville is a busybody. He's a woman acting real womanish. Glanville, Love, and Hilton gossiping like women over, over 13 pages of transcript about attorneys Shart, Melnick, and Steele. It is not a fair trial when in an ex parte meeting, Glanville, Love, and Hyatt assassinate the character of attorney Melnick and attack his integrity, alleging that he is not acting in the best interest of his client, Kenneth Copeland, aka Little Woody. It is not a fair trial when in a secret ex parte meeting, Glanville, Love, and Hyatt gossiping like women attack Kayla Bumpus for allegedly hugging Kendrick and stating that she is incapable of representing Woody. It is not a fair trial when in that secret ex parte meeting, Love lies to Glanville about an email she received from attorney Melnick. It is not a fair trial when in the secret ex parte meeting, Glanville starts talking about outside agitators, stating, my comments today were predicated on there's a lot of stuff going on in the background, but it shouldn't have to do anything with you all's case. It really shouldn't. But I think in some way it does, the outside agitators. It is not a fair trial when in that secret ex parte meeting, Glanville and Love have the following outrageous conversation. To wit, you want to read this, AV?
Yes, Glanville. But I think it does in some way outside agitators, Miss Love, that too, Glanville, and everybody else who I think are trying to influence Miss Love. That is absolutely happening.
That is absolutely happening. It is not a fair trial when Glanville, Love, and Hyatt have this further discussion. AV?
Miss Hilton, there's a lot going on. Miss Love, there is a presence. Yes, yes. That is all I'll say. Glanville, I mean, but I see it from just being in the courtroom and tracking.
I got it right here. How many violations of the Georgia Code of Judicial Conduct does it take to get a mistrial with prejudice in the state of Georgia? This case is like an old house that the present honorable judge is tasked with renovating. Every time a piece of pasted up wallpaper is removed, more rot is found hidden underneath. No Herculean effort by the present court can fix the due process violations of the last court. This house must be torn down. A mistrial should be declared and retrial barred due to prosecutorial and judicial misconduct that has goaded Kendrick into the present motion. Wherefore, Kendrick respectfully continues his request that this honorable court declare a mistrial based on at least due process violations of Kendrick's constitutional rights under the federal and state constitution. Today, this 31st day of July, 2024, respectfully submitted Doug Weinstein.
This morning, hot off the press.
Weinstein. All right, now they were super hot about this. Now, I'll be honest with you guys. I'll be honest with you. Based on how hot they were, I thought there was going to be a little bit more in this transcript.
Yeah.
This transcript is bullshit. But we saw how bad the first secret meeting that we found out about. It seems like they are mad about, this whole the outside agitators. Doug Weinstein did not like that. In fact, that was the first thing you put in the dang motion, the outside agitators. He brings it up multiple times. Doug Weinstein talks about the outside agitators here, outside agitators here. And this right here, we heard Doug Weinstein say in court this morning that everybody was against Judge Glanville. Everybody turned on him. Steele turned on him. Sharp turned on him. I was the only one that was still calling him honorable. Doug Weinstein said, I was the only one that was defending him. What does Weinstein say now? Weinstein says, a reading of the rough transcript highlights that which has been obvious to all observers except for me. Kendrick's counsel, except for me. I was the only one blinded for the last 19 months. I thought he was a good judge. Everybody saw through it but me. But now, based on this, now I see the light. Right now, I'm not fooled anymore. Now the wool is being pulled from my eyes. And y'all saw Sharp. Sharp was damn near screaming this morning in court.
Yeah, he was not happy.
And so I think, guys, apart from, I think that the reason why they are so mad, there's two reasons. It's not just this transcript, because when we saw how mad Sharp was, we were all like, we got to read the transcript. We got to read the transcript. We just read it. Is it bad? Yes. But for them to be hot like that, no. But what it is, it's the cumulative effect. The cumulative effect. It's this transcript on top of the other transcript of the secret meeting. Now we're finding out that there are two.
Yeah. So they had this Friday secret meeting and then they had that Monday secret meeting. So they did it twice.
Yes. It's it's real bad. It's like if you find out, let's say you got a wife and you find out that your wife was cheating on you for the past 6 months with a coworker. And y'all got these kids and she admitted it to you and she's crying. And you're like, man, this is so messed up and you don't know what to do. And, you're kind of giving her the silent treatment. Y'all are in the same home and you're just like, okay, I'm going to try to pull through it. I'm going to try to keep the family together. 6 months with this dude, 6 months. You're so mad. And then she tells you the next day that, she kissed another man on the cheek, right? She just and you explode. Now, kissing another man on the cheek is not as bad as cheating on you for 6 months, but it's just the cumulative. That's when you're like, oh, fuck it, bitch. I got a divorce here. You kissed the dude on the cheek. It's not, which is bad because you don't want your wife kissing dudes on the cheek. But it's the fact that it was already sitting on top of the 6 months of cheating. It was already sitting on top of the secret ex parte meeting. So the cumulative effect had these damn attorneys, they were hot as hell. They were hot.
They were done. They're just like, there's another one. And this is the thing. Judge Whitaker actually made that transcript available to them last night. So they didn't even know.
They didn't even know. So when they read this, they were like, oh, bitch, I got to kill you. And so we saw Sharp, and he was mad as he was steaming mad. He said the steam is coming off his bald head. All right. So what we'll do, guys, because the court is coming back, and this was very, very interesting. And I don't know, I certainly didn't stream yesterday, but I was catching bits and pieces of the interactions between this judge and the prosecutor. I don't think they like each other. And I don't know if they've had some past dealings, But just as favorable as Glanville was to the prosecution, it is now flipped. And now you see just how disfavorable this judge is to the prosecution team. And I don't know, but I got to give it to this judge. She has been right. She has been extremely fair.
Yeah.
And she calls out Attorney Love's bullshit.
Mm-hmm.
She calls out Attorney Hilton's bullshit. And they are not used to it. Do y'all remember how bad they were fighting Attorney Love and Hilton? They were fighting to keep Judge Glanville on the case. They were responding to every motion to recuse, saying, no, you can't recuse him because of this. You can't recuse him because of that. You have to keep him on here. You have to keep our team member, you have to keep Judge Glanville on the damn case. Because now that he's gone, now we see what the fuck's going on. This judge is like, hey, stand up and make your motion to me. But when you make it, and she stands up, then when you make it with case law. And then she's like, oh shit, Attorney Hilton. She's like, case law? Okay. And then she stands up with some little law student book, law school book. And the judge sees the book and the judge is like, no, I don't want the law from a horn book. If you've been in law school, you know what these horn books are. These are books that they teach us, the law. I don't want you using some horn book. I don't want you using some treatise. I want the statutes. I want the case law. And then Attorney Hilton was like, I don't have the case law.
Mm-hmm.
And the judge was like, I told you a week and a half.
A new season of New Beginnings. Content premieres Saturday, August 3rd, 8, 7 Central on Bounce.
Is Hilton is doing her work.
That's crazy.
You have all of these attorneys, all of these men, these defendants, these criminal defendants, everybody sitting around, the court reporters, the staff, the personnel, the security, everybody, the family members, the judge, everybody is sitting in court while Hilton is doing her homework in court. And then the judge says, hey, while Miss Hilton tries to figure this out, does anybody have anything else we can do? And everybody's like, no. And the judge is silent and everybody's just sitting there looking at Hilton trying to do her damn work.
That is why we are currently on break.
Yes. And so the judge says, well, I'm not going to sit here while you do your little research in the middle of trial. So the judge says, we're going to take a break. And I'll let you continue to do your research, which you should have done already. Glanville never would have said that. Glanville would have said, okay, let's take a comfort break and we'll come back in 3 hours.
3 hours?
He wouldn't have had no problem. Somebody write 3 hours.
Late lunches. We would have been back at 3 o'clock.
Yes, it is crazy. He had a whole 10 days. So this is what we are doing, guys. So let me pull up the law and crime again, and just to make sure where we at. The judge said that she is coming back at 11 o'clock, and you better know it is not going to be the 12:45 that Glanville would have done us.
No.
When Glanville says we coming back at 11, you know we coming back at 1:20.
Yeah.
This lady has been prompt and on point every day. So until it looks like we got a couple more minutes left, let's go back a little bit and watch the beginning and let's see some of these fireworks, guys.
Last evening, myself and Mr. Shard had a brief conversation regarding the testimony of Mr. Copeland. Yes, I believe the defense counsel have to speak among themselves in order to determine what portions of Mr. Copeland's testimony
See Shard's face.
be kept. And so we believe that we need a copy of the transcript.
Okay.
So that they can have that conversation. Once defense counsel has that conversation, then they'll speak with the state about their proposals and we can move forward from there, Your Honor.
All right, so I don't believe that I think we have the 7th available. I don't know that we have the 11th and 12th yet, but I think we've reached out this morning to Ms. Weaver, the court reporter, and I know she has some other people working with her as.
Hold on, let's get to Sharp. Let's kind of move this along a little bit because this was interesting.
I am going to say about the fact that here I am instead of Judge Glanville. But I mean, for that, I'm thinking essentially just
instruction that I worked on. That's what I'd like you to do. And Mr. Adams can opt out of this if he believes it. But I'm objecting to anything except the unvarnished truth about Judge Glanville. I would like the court to tell the jurors the truth, that he has been found to be disqualified and removed from this case for his conduct.
This is what I told you. Do y'all remember when Woody was in that secret meeting and they brought Woody in handcuffs? They brought Woody into that secret meeting in the judge's chambers in leg shackles. They brought him in belly chains. And they said, they talked to him and they pressured him into testifying. And in the last moment, they said, okay, well, you're going to testify. We need to change you into some clothes, some nice clothes. Woody said, hell no. Let me come out here like this. Let me come out here in the belly chain. That's right. Let them see what you did to me. Don't hide it. What did the judge say right now? The judge says, well, you know, I don't really know what I'm going to tell the jury, but I'm just going to tell them, hey, I'm the new judge. What did Brian Steele say? Brian Steele said no. Brian Steele said, I object to you telling the jury anything that is not the complete, unvarnished truth. Tell the jury how Judge Glanville was corrupt. Let them know. Why are you hiding it? These are members of our community. These are members who are paying for this trial. Guys, I'm paying for this trial. I am a member of Fulton County. I deserve to know the truth. The members of this jury have put their life on hold for 2 years. Let them know. This is what Brian Steele is saying.
Your Honor, I wouldn't, and Mr. Adams can opt out of this if he believes it, but I'm objecting to anything except the unvarnished truth about Judge Glanville. I would like the court to tell the jurors the truth, that he has been found to be disqualified and removed from this case for his conduct. And that's my instruction that I worked on. That's what I'd like you to do.
all right, well, I'll consider everything once I've got everybody's proposed instruction to the extent anybody wants to provide one for me to think about.
Thank you.
And Your Honor, I believe that the statute, if I'm not mistaken, regarding recusal specifically, speaks to the fact that that is not to be made a portion of the case in chief of the main case. I'll get the exact language that I'm speaking of.
All right, great, thank you, I appreciate that. Okay, anything else?
Yes, Your Honor. We also briefly discussed yesterday the exhibit list, talking about how we can resolve working through the exhibit list. And my understanding from Mr. Shard, I'm not sure if Mr. Kokomo was finished yet, but Mr. Kokomo, who's his legal assistant, and another legal assistant, we're actually working through the same thing that our legal assistant is working through. And our hope is, hopefully the court will be okay with this. By next Wednesday, our legal assistant would have gone through every video to assure we have all of the correct exhibits. But it's taking time because she's literally watching every single time we're in court.
I'm not okay with waiting until next Wednesday. I mean, I'm hoping, and it may be a false hope, but I'm hoping that we'll have a jury back with us by next Wednesday. So that needs to accelerate.
Okay, well, we will work on accelerating that list to get it to the court. But I believe that there.
And let me stop her right there. She's saying that she hopes that the jury comes back by next Wednesday. What's the problem? The problem is that she had said previously that the jury was coming back on August 5th, right? She said that little Woody was going to testify on August 5th. So now that looks like it's in jeopardy, which is a good thing because I want to stream little Woody on the stand and I am not available August 5th. So now she's saying like it's looking like this is pushed back. So she's hoping that there's a jury on Wednesday.
Working on it as well.
Well, they need to accelerate as well if their thought was next Wednesday. I mean, like, I'm thinking this Friday, okay? Which is the day after tomorrow. All right, with regard to And you're talking about the videos of his testimony, right? Or are you talking about?
No, I'm sorry, I should have been clear, to confirm what exhibits have been admitted and not admitted. That's what we've been working on. That's
The giant list of.
the giant list of exhibits.
Yes, that's fine. That can be next Wednesday. That's not that urgent. As long as we've got that correct by the end of the trial, that's all that really matters.
Yes,
for
Your
that.
Honor.
I thought you meant Mr. Copeland's testimony.
No,
Okay,
Your
all
Honor.
right. My misunderstanding then. Okay. All right. So with regard to the video interviews of Mr. Copeland, I suspect there are parts of those that the state knows they intend to be using or suspects very strongly they probably need to be using. So can we either come to some form of an agreement about evidentiary rulings that were already made, and or let's figure out what I need to do again?
Yes, Your Honor. I believe after we had the initial arguments regarding some of the redactions, some of the redactions we did concede on. So once I get that list, I can let.
Well, I've already seen those with regard to a couple of things, but I haven't gone through. I mean, I was looking at, for the transcripts I had, the arguments that y'all had already presented. And I saw that there were maybe like a couple, I don't know which, I can't remember right offhand which dates I've already looked at, but there didn't seem to be those within. So we have.
Okay, here we go. Here we go, guys. Here comes Sharp.
Out of them, we believe that there might only be two that we think may need to be re-argued.
Okay.
We don't think there's many, at least from state's
All
perspective.
right, that's good.
Shout out to Mama Bear Moment.
Honor, I'm speaking for myself. Yesterday, we received the transcript.
Wait, let me slow this down, Sharp. Let me
Come
slow
on,
it down,
Max.
all right,
Let's go, Max.
let's go. All
The
right,
transcript.
We don't think there's many, at least from state's
All
perspective.
right, that's good.
here we go. Shout out to Mama
Your
Bear
Honor, I'm
Moment.
speaking for myself. Yesterday, we received a transcript.
Hello.
A transcript that was a transcript of an ex parte meeting that occurred on Friday.
Right, this is the
Before
one.
the Monday.
Sorry, I'm sorry, just so that we're clear for the record purposes. This is the transcript I gave y'all at the end of yesterday that reflects Ms. Love had said, oh, yeah, we had an in court on the record, but ex parte discussion that led to the Monday, June 10th ex parte. So that's what you're talking about.
Let me be more artful. Yes.
Okay.
We were made aware, leading to the recusal of Judge Glanville,
Shout out to
that there was an ex parte meeting that occurred on June 10th, Monday, June 10th. We were not told by the state, we're not told by the judge that that had occurred. We found out about it, luckily, and by happenstance. We then demanded a transcript. We complained about said ex parte, inappropriate ex parte meeting. At no point, when the court finally acknowledged that there was an ex parte meeting that occurred on Monday, June 10th, at no point did the court or the state at that point acknowledge, oh, by the way, there was another ex parte meeting that occurred on June 7th.
Híjole.
We sat there after finding out about one ex parte meeting and having to drag the truth out. We sat there and the state and their co-conspirator, the trial court, were silent about the.
And let's stop it right there, guys. You know, and professionalism is a thing. And he called, Sharp called Judge Glanville a co-conspirator with the.
When people are fed, futures are nourished. Join the movement to end hunger.
Let's keep going. TiVo it up here.
Copeland said.
All right, here we go, guys. Here we go. We back. Shout out to Kelly. That's exactly right.
And whether or not the fact that Mr. Copeland said, I said it, but I lied, if that would be grounds to, would that still be considered a prior inconsistent statement? And Your Honor, I have
shout out to Ken. All right, so again, we just took an over an hour break so that this woman standing up in pink could do her actual research, right? And the judge was very hot about that, but let's go.
3 cases for the court. Okay. I have Green to have a copy for the court, as well as a defense counsel. You're welcome. Green v. State, which is 317 Georgia 250, which is a 2023 case. Sconners v. State, 318 Georgia 855, which is a 2024 case, Your Honor. Sure, Sconyers, SCONYERS.
Sure.
V State, you're welcome. And United States v. Odom, which is a federal Sixth Circuit, United States Court of Appeals case for the Sixth Circuit. It is an older case. It is a 1994 opinion, and it's 13 Fed Third 949.
Okay.
May I approach with those 3 cases?
Yes, thank you.
Oh, sorry, I'll give it to you. 1 second.
It took her an hour and a half to get those 3 cases. This is like, man, you should have had these damn 3 cases from the beginning.
Mm-hmm.
Just like AV said, look at her. She up there scrambling and scraping.
I gave you green already. Which one did I give you? Thank you. You're welcome. You're welcome.
Shout out to the green-eyed lady. She got them slime eyes. Thank you so much, green-eyed lady.
All right, so Green seems to say that if you say you don't remember, that's a sufficient foundation. Is there, and that's the only one I've looked at so far, is there one that says, if you say, yeah, that was a total lie?
Yeah, so that's also in green, Your Honor.
Okay.
So if you look at page 5 of the opinion, Your Honor, about the 4th paragraph down in the facts of that case, Your Honor, it says during the course of their investigation, officer interviewed Corey Milton, who said that he knew Green had a green Camry, that Green told him that a cracker bucked, I shot him, and that it was not Baba, Hill's nickname, who shot someone. The state played this recorded statement interview for the jury at trial. However, before the interview was played, Milton testified that he did not remember an interview or Green telling him about a murder, stating, I be getting high, I don't know. After a break, Milton testified that he did remember telling law enforcement lies to try to get out of trouble and that he would say anything.
Okay.
Milton further testified that the investigators brought up his criminal record, including a federal conviction and state charges that were dismissed, and that during the conversation about Green, Milton was looking for help with this case.
Okay.
And those facts are analogous to what Mr. Copeland has said so far on the stand, that he was just trying to finesse his way to get out of trouble, that he said those things, but they were all a lie. And here, our Supreme Court in Green said, a witness's failure to remember making a
So hang on, you're talking too fast for the court reporter to take it down because you're reading. And where are you reading from?
Now I'm on page 7, Your Honor,
Okay.
Division 3.
Okay.
Dee Dee's like, lock him
and when the
out, leave.
courts- The analysis
Shout out to
is a
Dee Dee.
witness's failure to remember making a statement may provide the foundation for offering extrinsic evidence to prove the statement was made. They cite London v. State, which is 308 Georgia 63 at 66, pages 66 through 67. They further cite Bridgewater, which is 309 Georgia at Penn site 887. Which cited defendants denied recollection of making a statement, provided sufficient foundation for the state to present extrinsic evidence of the statement. Here, the state laid the foundation for the admission of the
You're right,
recorded
Becky.
interview when it asked Milton twice if he recalled making the statement, and Milton responded first that he could not recall making the statement, and then that he did recall but had lied.
Okay.
And so that is Green. And we also have Scaniers that discusses primarily that the state does not now have to go through every single inconsistency,
Okay.
but that we can now, the flat out denial of that statement, Your Honor, allows us to move forward in playing the entirety of the statement, Your
Remember
Honor,
what he's,
without going into further detail.
interrogation
That's kind of our
video.
summation of Scaniers.
All right.
And then,
When?
Your Honor, is a federal case on the same point as the Green case, Your
All right.
Honor.
Thank you. Appreciate it. Counter law, counter position from any of the defense attorneys?
Your Honor, I'm gonna let someone that's better than me respond, like Matt Sharp or someone. But I just want to state that the foundational element for this argument doesn't even exist because we don't know what Mr. Copeland has testified to. I mean, everything he testified to after the 12th is void.
You mean we don't know what he is going to testify to?
Well, we certainly don't because we.
Right. No, I mean, I don't think anybody disagrees with that.
Okay.
But what I said was, let's go ahead and things that we think are very likely to still be an issue.
Good news, New Jersey. Under the Murphy administration, New Jersey has taken steps to maximize financial support to make health plans more affordable than.
Who knows what he's going to say? But yeah,
I'm gonna say I don't recall.
something that would give a foundation in order for it. But assuming that he testifies generally in the same way that he did before, which was according to y'all, and I've seen some of it, that was a complete lie, then we will face this. And so let's figure out what the.
So we're guessing what you may say based on.
Right, because I am trying to get prepared ahead of time instead of having to do all of this.
Getting ready for
while we're
Woody.
in jury. So yes, absolutely. Okay.
And
Let's see if she
if
wins.
anything, I do believe, remember that there were at least 2 full days of testimony from the 10th to the 12th. And
Yeah.
it's a state's remembrance that the I lied started early in his testimony. So,
Okay.
but we can
Thank you.
deal with that as well.
And with regard to that, the court reporter has said that she probably, what did she say, Ms. Firstfield? You talked to her. I didn't.
She is working on the transcripts of Mr. Copeland's testimony, and she said by either late today or tomorrow morning. She
Oh,
should
wow.
have, I believe it's June 10th. Sorry, June 11th.
We're gonna get Woody's testimony in writing, guys.
Shortly thereafter.
And do we already have June 10th or did he testify at all on June 10th?
He testified on June 10th, 11th, and all of the 12th.
And did he take the stand? He took the stand at least on June 7th, right?
Took the stand. I asked
Okay.
3 questions and now.
All right. So do we already have the 10th? Somewhere, we'll figure that out. But anyway, it should all be forthcoming soon. Okay, Mr. Steele.
Here comes Brian.
Your Honor, I don't think that the state's cases, from what I heard, I did not read them, I just heard the discussion, are what we're looking for, because those cases are, I don't remember, or I was on drugs, or I don't recall, but I found a case, it is pre the new evidence code.
Okay, so hang on just a second. So I didn't know, did y'all didn't, it's fine if y'all don't have copies of it, but you have the site to it. But looking at it, it does actually look like, in addition to saying, I don't remember reading right from the case, he says,
This is Brian's counter argument.
Milton testified that he did not remember an interview or Green telling him about a murder, stating, quote, "I'd be getting high, I don't know." After a break, Milton testified that he did remember telling law enforcement, quote, "lies to try to get out of trouble," unquote, and that he would, quote, "say anything," unquote. So it sounds like that is pretty close to what we've got.
That is close to Woody.
Okay, maybe I have to study it, but I found a case. Now, my understanding of 24-6-613 is it did not change much of our former evidence code. So I'm about to give you a case from 2011, but it is obviously, if you disagree with that, then it should have no application if it doesn't carry forward.
All right, so you just said 623?
24-6-613, if I said
Okay.
23, I meant prior inconsistent statement.
Okay.
That's what the state is traveling under that.
Yeah.
And then prior or impeached testimony or testimony by contradiction. So I found this case, if you don't mind pulling it up, or I can email it. Johnson, Johnsson versus State. Your Honor, it's 289 Georgia at 106. It's Division 3. And that is 709 Southeast 2D 768 2011. And I think that it's on point bad for Mr. Williams, but it says over objection to trial, but we just follow the law. So over objection, the trial court allowed the prosecutor to play the entire tape of an out-of-court police interview of a witness for the state. Johnson urges that the particular statements made during that interview, which were inculpatory of Johnson, were inadmissible as prior inconsistent statements because the witness had admitted making them, but testified that he lied to the police. And it says, however, the fact that the witness admits that he or she made the prior inconsistent pretrial statement does not render it inadmissible. We have rejected that assertion that a prior inconsistent statement is admissible only if the witness denies making the prior statement, but not if he simply disputes the truth of the earlier statement. There is no such denial requirement under, and again, I don't want to mislead the court, it's under the former 24-983. Then I looked at Cummings, which is cited, which is Cummings versus State, which is 2.
Sorry, guys. People are asking what's happening. We have an argument between Brian and Simone right now. Simone is trying to get in all the police footage because we know that Little Woody has admitted to lying. That's why they need the police footage. Brian Steele is citing a case to combat that. Simone had to do research for an hour and a half on 3 cases. And right now we're going to see what Judge Whitaker decides. That's what's going on.
3.
Yeah, so it looks like in that case, he just refuses to answer whatsoever.
Exactly, which is really obviously, saying I don't remember, I don't recall, I don't, I may have said something. Those things trigger a prior inconsistent statement. I thought that's what the Green case is that I have to study that the state just cited. But I wanted to bring to your attention that language that I just gave you out of Johnson, I thought right on point and bad for my position, but we just tell the truth. So I want to argue with it. But then we always look back. We're always taught to look back on the cases cited, and that former case doesn't promote that position.
So it appears to me, and I'm just looking at Cummings right now too, but so it looks like the defendants, appellants now at the appellate stage are saying, hey, a prior inconsistent statement is admissible only if I deny making the statement, not if I simply say it wasn't true. And the appellate court is saying, no, that's not correct. You don't have to deny it. Even without a denial, it can still come in. That does not mean the flip is true, that the other part, not simply if he disputes the truth, is not a way to get it in.
I agree.
So I mean, you can take a look at Green, but Green seems pretty on all fours. So I'm thinking unless I hear something that either overrules Green or causes me to severely question Green, Green controls, and if, whether he says, I don't remember, whether he says, I never made the statement, or whether he says, yes, I made the statement, but what is a total lie, all three of those, it appears under our current state of the law, would permit then the introduction of prior inconsistent statements under 613.
Well, I'm going to read with your permission.
Sure, yeah, absolutely.
Yes. Thank you.
All right. Thank you, Ms. Hilton.
All right. What do we think, Judge?
That was a helpful use of our break.
Oh, shade.
All right, so with that understanding, are there other specific evidentiary
Shout out to Troya.
issues we want to consider? Or do we want to just jump right into hashing out some of the evidence?
Your Honor, during the course, the state also looked at the redactions that we had previously
Okay.
discussed with Judge Glanville for the state as it relates to the January 11th, January 28th, February 20th, and February 21st interviews.
Okay.
We do not have any issues with the redactions as is.
Okay, and those redactions being something that the defense and you all have agreed to?
It was what was hashed out during.
The state of it. Okay, so were those hashings out done prior to or after the recusal motion being filed?
It was
That's where we left
done.
off.
3 of them were definitely done after the recusal motion was filed.
Okay.
Didn't
Well,
finish.
the one done before the recusal motion was filed, we can go with, however, that ultimately ended up being redacted.
Yeah, I'm trying to recall if the other, I know we were in the middle of playing
We were at jail phone call.
2 of them during that time period. I just need to confirm when we actually discussed those 2. So January 11th and February 20th, we actually played those interviews before the jury. I believe we played those interviews on Monday, June 17th.
And which would be part of what either needs to get redone or y'all need to make a,
Yes,
come to agreement on.
and we may have started it on Friday, the 14th, whatever that Friday was before. But for the ones that we did discuss during that pendency, the state does not have issues with those 4. As it relates to June 11th, the June 10th interview, there are some we would like to revisit. So,
All right, I'm not sure I follow you.
Okay.
So. What, you say you want to revisit. So I think first it would be helpful to know which ones were hashed out before the recusal motion. And then we can just say, that's what we're going with, because that was
They don't
prior
remember.
to any issue. And therefore, we can stay with that.
Wow.
As for anything that was post recusal motion, unless the defense can come to an agreement with y'all about admissibility, we're going to have to redo all of those.
Oh my God.
So
Wow.
We got to start over with Woody.
Have y'all had discussions yet about, or I mean, I thought y'all wanted to figure out what was actually done and what wasn't.
and I guess maybe I misinterpreted what I thought the court wanted us to figure out whether or not there were some that we wanted to even object to. And so we're saying there wasn't any that were done that.
At Commonwealth Charter Academy, we understand that family comes first. That's why we provide families full academic transparency and the opportunity to customize their child's cyber education based on their interests, career focus, and unique learning style. Through our collaborative family service outreach, student support, and onboarding programs, we work to foster the connection between CCA and the families we serve. Choose family. Choose CCA.
cases to the judge. And then Brian Steele stood up because she asked the defense side, she's like, does anybody have any counter arguments, any counter cases? Brian had one. It seemed like she was kind of leaning more towards Simone, but she didn't rule on it. So instead of giving a ruling, she's like, matter of fact, let's talk about Woody, right? Where did you guys leave off before this case? Remember, Simone was trying to get all those those interviews in, like, you know, the really bad audio ones, where since little Woody was not cooperating on the stand, they now have to use these interrogation videos. And we spent days going back and forth on whether those videos were going to come in. Where we left off before the recusal was us reviewing the interrogation videos and the jail phone calls because little Woody's not cooperating. So Simone is talking about that because they need it. And the judge is like, well, actually, hold on. Where did you guys leave off? Did you agree with the defense counsel that they're coming in? But here's the other thing. She's like, I think we need to start over with Woody. So remember, we're talking about Woody's testimony in general. I think that's one of the big goals for the day, to figure out, are we going to do this over? And she just said, we might have to do a redo.
Wow. So we might redo Woody's testimony all over. All right, guys.
You will let me know which one or ones of those were hashed out before, and where that is, you know, status quo on that. For the other 2 or 3, whether they were before or after, y'all are good with what was decided, but I'll have to find out from the defense whether y'all are good with what was decided, and if not, what particularly you want to revisit.
Yes, Your Honor.
Okay. And then there was a 5th one.
For June 10th, there are areas we would want to.
And that has not been gone into with anybody yet. Is that true?
No, we did hash out that one as well.
Oh, you want to revisit that one?
Yes, Your Honor.
Okay. Okay. All right, can anybody from the defense give me anything close to definitive about whether y'all are good or want to revisit the evidentiary determinations?
Let me just stop it right here. Shout out to Thinking from Texas, Whitney. Excuse me, guys. Thank you so much. We have a new stream sponsor, and Whitney has sponsored so many streams. Y'all know, let me center myself. Y'all know I don't ask you guys for much, but please, guys, please, everyone spam the chat. 5,000 people in here. Somebody write Whitney in the dang chat. She is sponsoring the stream that you guys are watching, the stream that started off so explosively. This has been amazing. Thank you so much. Thinking of Whitney. Note, Thinking from Texas, Whitney. No comment, no question, just the pure love of the game. Thank you for shouting her out. Shout out to Texas, and shout out to Thinking from Texas, Whitney. A huge supporter of me, huge supporter of AV and of the channel and community. Thank you, Whitney. You are amazing. You are absolutely amazing. Great to see you. Hope you are doing fantastic this Monday. Thank you, Whitney. Shout out to Whitney.
It's Wednesday, lead.
What's today?
Wednesday.
What did I say? Monday? Oh shit, I'm retired, guys. I'm sorry. It's like a Monday to me. I had to wake up early to get this damn thing off at 8. I'm sorry, guys. All right. Wednesday, Monday, whatever it is. All right. Thank you so much. Thinking from Texas, Whitney. And thank y'all for shouting her out. I know we got 5,000 people in here, and I don't stop the chat lightly or stop the stream lightly. But when somebody supports me and supports AV so much, I absolutely want to pause it just to express my gratitude and appreciation. So much love, so much encouragement, so much support that Whitney shows me. So thank you to everybody. Everybody, y'all support me, supporting AV so much, but sometimes y'all go way over and above, and I absolutely want to stop the show for a second just to express my appreciation. Shout out to Miss Whitney. Thank you so much. Thank y'all for shouting her out as well.
Made as to any of those.
and respectfully, and I'm not trying to belabor the point, but I just need to make a record. Our stance is that our trial judge was not an impartial.
I understand.
And so we don't believe that the issues are just limited to post serving the recusal motion at this time.
Okay.
So
got
that's, and we understand.
I am not going to be going back and revisiting evidentiary rulings made before then.
I understand. And I just need to say that.
But yes, for the record, I understand.
This is a very difficult task. I was I think we all were very involved in the negotiations and reviewing of these things. But, as we were doing it, I wasn't taking notes of what I was doing. So I'm trying to put together what exactly was discussed. And part of the problem is we don't have a transcript.
Well, I've got some of the transcripts, but not all of them. So if it would be helpful to y'all to have the transcripts of when the jury's out and y'all are going through, we don't have all of them yet, but I've got certain days. So y'all did that like on the 18th, the 20th, and the 21st.
Man.
And the 24th, and the 25th, and the 26th.
It's a long time.
Okay.
They spent
Which
days
is
doing
why
that.
I want to use this week to the extent possible to not take 1, 2, 3, 4, 5, 6 different days to do that. Okay, so I'll see what we already have and get that out to y'all. And again, y'all, this is all rough. This isn't official, but it looks pretty clean to me.
And there were extensive emails that went back and forth from myself and other defense attorneys with Ms. Hilton mostly regarding these kind of negotiations where we agreed and didn't agree at the time.
Okay.
So I'm trying to check my emails and make sure I have.
So y'all have those or should have those. So.
And that would be a good starting point. I'm just making sure that what I have is accurate to what she has.
Okay.
You don't want to do it. I wouldn't either. 6
I'm
days.
sorry, I don't have a better answer for you.
Okay.
So 6 days for what now? What are they talking about?
It took them 6 days to put together a transcript from, I believe it's like 16 or 19 hours of footage from Little Woody. And they've gotten through 6 days of it. Because remember, like that week after he couldn't be on the stand, they had no choice but to use these videos, jail phone calls. But Glanville wanted them to transcribe it. So she's looking at it like it took you guys 6 days in court to do this.
Yeah, she ain't feeling that, but I don't know. We'll see.
Yeah, for Mr. Williams, let me kind of echo what Mr. Sharp just said. It wasn't very involved, and I'll be candid with the court. I have several boxes, and one of those boxes contains my notes. It got to the point where Ms. Hilton and I were kind of back and forth in court on the day of and sending emails. I don't have those with me. I think what Mr. Shard is saying, and if he's not saying it, I'll say it, that we really need some time to kind of get all that together.
All right, y'all.
Yeah.
When I met with y'all, when was that? Friday, a week and a half ago? And said, okay, here's how we're going to move forward. And then gave y'all 10 days or so before we had our Tuesday, hey, we're doing motions now, and then we're going to move to evidence. Y'all should have used that 10 days to be doing this, because we literally talked at that time about we're going to need to go back through some of Mr. Copeland's evidence, and we're certainly going to have to reach what hadn't been reached before. So I know I can't reverse this all back to 10 or 11 or 12 days ago and have y'all then make better use of your time up until now, but y'all, that's what I meant when I said we're going to be doing the evidence this week. So y'all may have a really long night tonight, I do not want tomorrow to be as unproductive as today. And yes, it will help when you have transcripts. And so to the extent I can, will get transcripts out to you as I get them. But with regard to discussions y'all were already having amongst each other, it wasn't that long ago. So. Okay. All right, so how about another witness? If we can't work on Mr. Copeland right now, is there some other witness that we know is gonna also have a lot of evidence that is gonna be contentious?
Mr. Zachary. Sorry, Mr. Zachary.
Your Honor, Mr. Zachary, there are other witnesses.
Okay.
We've not gone over. Well, we have turned over the statements that Mr. Zachary has made.
All right.
The police that we intend, if necessary, to use for impeachment purposes.
Okay.
There have been no motions in limine regarding any portions of those statements, as we don't know what, Mr. Zachary has not yet testified. And, we would hope that he be truthful in his system, but we don't know what he's done.
Okay, so.
Fake ID documents are a serious threat, easily ordered online. Fake IDs can get used for anything from underage drinking to identity theft to terrorism. Think twice if you consider this a minor issue. There is a powerful and proven solution to protect IDs and check their authenticity: the kinogram. The kinogram is so difficult to imitate that fake ID documents are easily detected with the naked eye. Identity documents need secure protection. Learn more at kinogram.com.
A contingent ruling, but if y'all as the defense have Mr. Zachary's statements and have taken a look at them and know what you think is going to be potentially objectionable, if y'all want to give me those statements, make those objections, I'll hear a response, and then we can try to get through that. That would be great.
And with the court, is the court asking for a copy of each of his statements? Because we can try that.
Yeah, because I'm going to need those if I'm going to make rulings. So yes. And I know in this day and age, almost everything is a video statement. I also know that for Mr. Copeland, when y'all were litigating the evidentiary issues, you had transcripts available, and that would be immensely helpful. It is a whole lot faster because a lot of the statements aren't going to be anything anybody has an issue with, or you're going to have agreed that's not relevant, it's going out. If you can say that's on page 7, lines whatever, I can go right to that instead of listening through 5 minutes of that before I get to page 7. So I would love transcripts to the extent we have them. And then of course, if in court I need to, for a particular reason, watch and listen to the video that is the relevant, cogent part, I of course will. But as to, a 5-hour video when there are 20 minutes that are really at issue, if we can hone in on the 20 minutes via a transcript, that would be ideal. Okay, so is anybody ready to go on Mr. Zachary?
No.
Anybody?
No.
Does everybody have Mr. Zachary's statements?
Yes.
Okay.
Shout out to Keita G, another attorney.
I'll take the hit here.
They do keep sending you up here to be the one.
That's okay. I'll take the hit. So there are thousands and thousands of pages, and probably thousands of pages of transcripts. So we have a digital copy. I'm sure someone has the full discovery here, but we all have printed out copies of his statements. I know my copy
Y'all are all old like me and you like paper.
And because we have our notes on the paper too. And so
Yeah.
I didn't know that Zachary's statements were going to be on the agenda for today. So
Yeah.
I didn't bring the transcripts with all my
Yeah,
notes.
I mean, they shouldn't have been on the agenda because Kenneth Copeland was the agenda today, but
Understood.
okay, yeah, I hear you. You're not ready, but you can be ready soon. So when you say thousands of pages, do you mean period or thousands of pages for Mr. Zachary?
Mr. Zachary, to my recollection, has at least two, I believe maybe three statements.
Okay.
And I'm estimating here, I would say a total of about 9 hours of
Okay.
talking.
All right. Has the state determined whether, so I know, like, for example, for Kenneth Copeland's jail calls, I think you had 11, but you said we're only interested in 6 of them. Have y'all done that type of winnowing for Mr. Zachary and the other witnesses that you're going to be getting to soon?
We have been, not entirely, as the court said, down. We have identified jail calls of particular, not witnesses, but defendants that we intended to use. And when the court says particular witnesses.
I mean, Mr. Zachary is a witness, right?
But I don't have,
It's your witness.
I don't believe that we have any jail calls from Quindary Zachary.
Oh, no, I was just using that as an example of winnowing. I'm not asking about jail calls from Mr. Zachary. I'm asking about whatever you think you might use with Mr. Zachary. If there are 3 statements, for instance, do you intend to use the entirety of all 3 statements? And if not, could you pinpoint for the defense what portions of those statements you intend to use so that if they have an objection to something you're not going to use, they don't even need to look at that because you don't intend to use it. So you can say, here's the portions we think we want to use, and then they can say, only look at those. Here are the objections we have.
Yes, I can do that. I have not broken it apart.
Okay.
Segment scientific.
Okay.
As I wasn't yet.
At him. I don't know when he's going to come in, but all right. So as a part of all of the work y'all are going to be doing before the 5th, that's going to be part of what you need to do.
And not just for him, just so that.
Yeah, for everybody, for your next 30 witnesses, and then for your next 30 after that.
And so if, not trying to tell the court how to use the court's time, but if during.
I'm open to suggestions since what I've come up with so far isn't working.
What we can do as a prosecution team over the next, however amount of time the court wishes to allow us, is to identify with respect to each of the witnesses that are co-conspirators. I know that there are several. We can, and that it will be coming up in the next batch of 30 witnesses. So we can identify just to the court and the defense, those people, and begin looking at the portions of their statements, their respective statements.
Hurting my ears.
That we would anticipate needing to use as opposed to using the whole thing.
Okay.
And so we should be able, over whatever amount of time the court gives us from here forward today, to go through and come back today with a chunk of statements for each of those people.
Okay.
If not all of them.
Okay. I like what I'm hearing there, that by the end of today, she have done that for all of them. Yes, I like that.
All right.
Yes.
Yes.
I said it, so
You did say it.
There we go. But I overshot.
You might have overshot. All right. Well, hey, if you can even do it for one, that'll give us something to work on. And I thought you said you could do that before the end of today. Okay. So anyone, are we ready on anything right now?
And again, guys, what the issue is that before she came on, they had told the jury that they would not have to come back until August 5th. And so now what she is trying to do is rush and get everything that they need to get done outside of the presence of the jury. She wants to do it right now. That's why she was so mad at Attorney Hilton for wasting over an hour of time. And so she's looking and she's like, guys, what do we work on? Let's go, let's do something, because I know you fuckers are gonna have all these motions next week. Let's deal with them right now. And she asked to deal with one specific witness, and Attorney Sharp came up and said, listen, there are thousands and thousands of pages of transcripts. I didn't even know we were going to be doing this. So, I didn't bring all these thousands of pages to court today because it wasn't on the schedule. And so what the judge is running into is like, oh my God, this case actually is a shit show. It's so big that it's everything is so slowed down. So that is that's the issue that this judge is running up against.
It's not anything. It's not anything we can go forward with, but Judge Glanville had given me, on behalf of Mr. Nichols, a continuing objection to the admission of any of these statements, in that they have absolutely nothing to do with Mr. Nichols. So I have a continuing objection to the admission of these statements.
All right.
I have a continuing objection, which has been preserved by Judge Glanville, with regard to both the alleged co-conspirators exceptions and any of the contained so-called statements that were made by Mr. Copeland or the other alleged witnesses that the state has called. Last year, we had motions pending with regard to 801D2E issues, co-conspirator statements issues. The court indicated that, well, it required the state to provide to the defense all of the 801D2E statements that the state contended it would seek to admit during the course of the trial. That notice was filed on or about by the state on or about, excuse me, November 3rd of last year, obviously. Couldn't be this year yet, although it feels like it. That state's supplement to state's motion to introduce co-conspirator statements and notice of intent to introduce the same, they only noticed 3.
1400s. Ancient Incas freeze-dry potatoes at high altitudes. 1940s. Freeze-drying keeps medical supplies from spoiling during World War II. 1960s. NASA uses freeze-drying to create meals for astronauts. 1970s. U.S. military uses freeze-drying to improve Army rations. 1980s. Commercial companies begin to freeze-dry food using freeze dryers that cost hundreds of thousands of dollars. 2013. Harvest Right develops the first affordable freeze dryer available for home use. Today, Harvest Right continues to lower the price of its freeze dryer while continuing to make the freeze dryer better and easier to use. So why freeze dry from home? Freeze drying is the best form of food preservation. Freeze-dried food is lightweight and can be stored at room temperatures for up to 25 years. Freeze drying has definitely improved over time. Now it's time to improve your life with a home freeze dryer. Visit harvestright.com to learn more.
That's correct.
Do you want to, I think I invited you previously to, but if not, invite you now to provide me a proposed 105 limiting instruction, and I'll take that under consideration.
Sure.
And I'll do that for, I know that all 6 of the defendants here are charged in count 1, the RICO count. And then other than that, there seem to be sort of 8 or so independent, or not independent, but different acts or sets of acts that some people are charged with 1 or 2, some people are, charged with another set. And yeah, I mean, the people that are not charged with Mr. Thomas's murder might want
Me too, Ty.
some sort of instruction that says, other than the gang count, other than the RICO count, this doesn't go to this defendant. So I'm happy to consider some instruction if y'all want to provide me something to consider.
I will provide you with
Okay.
that, whether you ultimately do that or not.
Yeah,
this is
I don't
what
know.
we've
I'll
been
hear from
arguing.
both sides. But
Yeah, it's what we've been arguing about the whole time and what I've preserved going forward.
Sure.
All right, so we'll get you that
Okay.
as soon as possible.
All right, guys, that was Bruce Harvey. He just stood up, and basically what he was talking about is a standing order that he had with Judge Glanville dating back to November of 2023, and it's really centered on co-conspirator statements. What the agreement is, the state must give advance notice of the statement to the defense attorneys. And that has been on notice since November of 23. Bruce Harvey is objecting because he's only saw 3 of them. So that's what you're seeing there.
So, Your Honor, the November notice of 2022.
2022?
We provided 2 801 D2E notices.
Okay, so is one of them November 3rd of 2023 as?
Yes.
Okay.
Yes.
And then you're saying there's another one?
Yes, that's November, that was filed on November 30th of 2022.
Okay. And give me a second, Laura.
Let me give a big shout out again to Thinking from Texas, Whitney. The judge is up there talking to her assistant. But please, guys, somebody write Thinking
Thank
from
you, Judge.
Texas,
In
Whitney.
the
Somebody write Whitney in the
2022
chat.
notice, we stated
Thank you,
that the
Whitney.
state will establish the ongoing conspiracy of the YSL Criminal Street Gang at trial, and any statements made between co-conspirators in the YSL Criminal Street Gang conspiracy that were made in furtherance of the conspiracy are admissible, and we request the court grant the state's motion to permit these admissible statements at trial. What we've seen come up, for instance, during jail recordings, there are persons who are not indicted under this indictment as a co-conspirator that make statements to either a witness or a defendant currently on trial, or in the presence of a defendant currently on trial, that the defense has alleged the statements are therefore inadmissible, despite the fact that they come within the context of a jail recording that arguably is admissible, that the statements of a particular party are not admissible. Instances like that, we argue, are instances that involve co-conspirator statements.
Okay, so not arguing broadly, conceptually, but arguing as to specific statements. What notice does the defense have of specific statements that are not included in the November 3rd, 2023 notice? Okay. Because it's one thing to say broadly, hey, if there are co-conspirator statements, we intend to use them. It's another to say, and here are the ones we intend to use. And if the court had ordered, you need to tell the defense which of these you intend to use, then it's Time to get down to specifics.
Yes, Your Honor. So in this particular notice, we did provide
Sorry, when you say in this particular notice, which notice?
the November 6, 2023 notice.
Okay. November 6th. November
Mom,
3rd.
gambler.
It's just, he said it wrong.
It's filed.
November, okay. You provided notice of 3 different statements.
Right. 3
Right?
specific ones.
Okay. Right?
Yes.
All right. So my,
Did she throw that dude under the bus? Hold up.
okay.
Notice, we did provide
Sorry, when you say in this particular notice, which notice?
the November 6, 2023 notice.
Okay. November 6th. November 3rd.
It's just, he said it wrong.
It's
just
filed.
6.
November, okay.
She sure did.
You provide
She threw her fucking teammate under the bus, talking about he stated it wrong. Did y'all see that? She could have been just like, yeah, okay, we said it wrong, or I said it wrong. No, she specifically threw that white man up under the bus. And that's supposed to be her teammate.
I did notice
Jesus
of
Christ.
3 different statements.
Right. 3
Right?
specific ones.
Okay. Right?
Yes.
All right. So my question is, are there other statements besides those 3 that you believe are admissible in the trial of this case as to any witness?
There are, just one moment.
All right.
I'm getting a full view here. I really don't want to see that. Oh, man.
Oh my God, that is hilarious.
And so that we are clear, because there's a
Hell no,
difference
it
of
be
opinion.
snapping.
So does the court mean out of all of the jail recordings, out of all of the wiretap recordings, out of any recording that we had, which of those contain arguably co-conspirator statements?
Yes.
There are many. There are many that are included in the.
All right. I have yet to find the notice that y'all are talking about.
The November 6th one? We can
Yeah,
send it to
because
the
y'all,
court.
there are a lot of filings
We can
in
send
this
it to the
case.
court.
But Ms. Persifield has saved it for me somewhere, but there are already a lot of things in our file also. So
We'll send it to the court and to counsel for defense.
Laura, what's it called? Where do I find it?
Her whisper is so loud.
The microphones be working.
Is emailing it to me because I need lots of assistance. Thank you, Laura.
And let me stop it right here. Shout out to Keita. And Keita is really making a point that, I was trying to express in my last comment, guys. What does Keita say? To be fair, no, she says, to be at this point, 103 days in trial is insane. This case should not have been brought like this. Fawny has egg on her face, such a waste of time and money. This judge is like, hey guys, let's talk about this defendant's testimony. Everybody ready? And they're like, no. This judge is used to trials that take a couple days, a couple weeks, even a month or something. So the judge is like, hey, let's talk about this guy. Sharp stands up and like, judge, this guy's testimony involves thousands and thousands of pages. No one brought all these thousands and thousands of pages to court. And the judge is like, oh shit. Can we do anything? No, there's so many pages, so many terabytes of data. This case is so big. And what Keita's saying is that you didn't have to bring it this way. You could have chunked it up or just done it all separately and just knocked them all out. But you wanted to get this huge case. And now the judge is in here wondering why this case is going so slow. You're talking about thousands and thousands and thousands of pages. Plus, you had a judge who was on some bullshit before. And so now this judge is coming in and she's like, man,
Yeah, she's starting to see it. It reminds me of Doug Weinstein's motion this morning, where he was, the motion for supplement, he was using the house analogy, right?
Mhm.
Like she has to renovate the house. And when you take the wallpaper down, you see that the walls are rotted behind. So they
Yeah.
were allowed to do this for 103 days, to Keita's point, but they should have been much more organized with how complex this is.
100%. So, I mean, this judge she's in for some bullshit. She's gonna find out real quick. This ain't no regular case.
And so was there an order at some point or a direction from the judge to tell the defense which statements she believed to be co-conspirator statements that led to this supplement?
Yes.
Yes, okay.
I'm looking for.
Okay, I mean, if there was, that's all I need to know. So yes, so, okay, now tell me what other statements you believe to be co-conspirator statements and why they should come in now when you were ordered many, many months ago to tell the defense what they were.
They are included as part of the jail calls and the wiretap.
Okay, so they have them.
Yes.
They just haven't been identified as, hey, we think this is a co-conspirator statement, we intend to use it.
Yes.
Okay, well, sure. Well, I mean, I shouldn't say sure. Sure, you can try to, whether you're successful or not, I don't know.
I understood. So when they say they've been provided, they have not been identified in any way, shape, or form. There are thousands of jail calls involving dozens of people.
Yeah.
There are about 3,000.
I think you've said enough. I understand. Them provided in discovery, not identified as here are what we believe to be co-conspirator statements. Thank you. That was kind of what I thought when she said you have them in discovery. All right. So I would imagine that the discovery in this case is beyond voluminous. And at some point in a trial in this day and age, you know, how it's supposed to not be trial by ambush anymore. It's supposed to not be trial by ambush. And I'm not saying you're trying to ambush, but at least as of now, really well before now, you should have identified. I think this is a co-conspirator statement. And honestly, you should have identified out of the God knows how many rooms full of boxes of discovery, here's what we're actually going to use. So to the extent you haven't done that, I've already told you you're going to be doing that by telling us very specifically as to each witness, here's the evidence I intend to use. But that's still weeks down the road. So if you know, well, let me put it this way. Whatever co-conspirator statement you know of right now, let's stand up and let's share it with the rest of the people here so that they can then tonight look at it and say, here's why it's not. Okay? And for anything that you don't know of right now, you need to go home.
True Lion says, lead, what is a trial by ambush? And this is, I'm just going to stop it real quick because this is what the judge is saying. The judge is like, listen, a trial by ambush, guys, is when it used to be back in the day, there was no discovery. So, you know, I have a case against you. I don't tell you anything. I don't tell you my evidence. You don't show me your evidence. And we show up to trial and have it out. And you don't know what the fuck I have. I don't know what the fuck you have. And it's a shit show. Mm-hmm. Now there's discovery. That's an ambush because I'm ambushing you with evidence. I'm ambushing you with testimony. I'm ambushing you with witnesses. Now we don't have that in America. Now you have to tell the other person, hey, who your witness is going to be, kind of what are they going to say, what the deal is. You cannot surprise me. There's no trial by surprise, no trial by ambush. And what the judge is saying is like, you, Attorney Love, you prosecutors, you guys haven't sufficiently particularized, you haven't sufficiently detailed what the hell you're going to talk about at this trial. You haven't told the other side that. Now, in the middle of trial, you're saying, oh, we're going to talk about this. Oh, we're going to talk about that. That's ambush. Mm-hmm. And so the judge is saying, hey, man, nowadays, you know, since the 1800s, we don't do trial by ambush anymore. You guys should have been particularized these witnesses, this testimony. You should have been told these people what these defense attorneys what you guys intend to show.
Yeah, and that's what Bruce Harvey kind of started this entire conversation on it, because he's just like, hey, there's unanswered things from November of 23. That's months ago.
Yeah, so it's interesting. So to answer that
Tonight,
question,
yeah.
this is what the judge is so frustrated about.
That's still weeks down the road. So if you know, well, let me put it this way. Whatever co-conspirator statement you know of right now, let's stand up and let's share it with the rest of the people here so that they can then tonight look at it and say, here's why it's not. Okay? And for anything that you don't know of right now, you need to go home tonight and huddle together and figure out what else there might be. And I will consider whether I'm going to let that in or not.
Wow.
And then if I do, potentially, we'll have to hear as to each of the alleged co-conspirators why it is that you either have or can establish through admissible evidence that they are in fact a co-conspirator, or not in fact. That'll be for the jury to determine, but there's a preponderance from which I can determine. Okay? All right, so who do you know of right now?
Cool. 1 second.
Okay. She said, give me 1 second. But yeah, I mean, I know it's a big courtroom and there are a lot of us, so we all need to try to remember.
She said, give me 1 second, I'm rebooting. I don't know if you guys can see this. Her computer's been off for 30 minutes.
Oh my God.
Computer has been off for 30 minutes.
What is going on?
Excuse me while I reboot. This lady is trash.
Remember to speak into the mics. So maybe the state can, and you're pretty loud, Miss Love, but maybe pull that mic down so it's a little closer to all of y'all.
She said, give me a second. She said rebooting. What she should have said was, give me a second while I turn my computer on.
Knows what I'm doing. I overheated. And so I had to.
By which you mean your laptop overheated.
I do mean my laptop. And I was
because I've told y'all not to overheat anymore.
So that's what's
okay
happened.
Judge Glanville would have taken a 30-minute comfort break right now.
At this time, we're going to take a comfort break. Take Jack outside.
Sure.
Could I just briefly address a side issue? Sure. When we met for the status conference, I believe Mr. Harvey asked you if you would support us when other judges try to
I
drag us
recall
in.
that. And you know what? Immediately thereafter, that very night, a federal judge reached out to me and said, oh, I'd like Mr. Harvey for trial. And I said, no, you can't have him. So
thank you so much.
Yeah.
But one thing that wasn't clear, or maybe I misunderstood it. You talked about when we say take a 1 week break, that if someone wants to call you in for motions, perhaps they can do that. So you were referencing that week last week where we were out and why we weren't working to prepare for this.
Right.
I was being called into court all over the state of Georgia, just because, and maybe that was my fault because I wasn't clear whether you would support us if I told those judges, no, I'm in trial. Because we did have a lot of preparation to do for this week, but unfortunately, I was hauled all over the state.
Right, and we didn't really talk about that.
Yeah, are you going to cover us for that as well so that we can work on this trial during those breaks?
Because, we may just have to decide that on a break by break kind of thing. Because I, for the last 19 months, have been one of those judges wanting several of you in court for cases pending before me on my other docket. I don't want to blanket say anytime we're not here working on the case, I'm still going to protect y'all, as it were. And frankly, I'm sure that all of y'all would like some time to be able to go represent your other clients in court as well.
Absolutely.
So, why don't we take that up kind of as we need to.
Okay.
And if we are not in court, I hope that we will get into a rhythm if this case proceeds to continuation of trial, where we can have enough done that we can say go Monday through Thursday hard and take Fridays off, or take Friday mornings for motions and Friday afternoons off or something, but like a schedule so that y'all know if you are not prepping for the main witness in the case the next morning, that you can go to court and do some of your other representation.
That would be wonderful, Your Honor.
Yeah.
At least speaking for myself.
Let's raise it with me when you need to, but
Okay.
I can't give you a blanket answer. Right
Okay,
now.
thank you.
All right.
Still waiting on love.
That's a background noise.
Shout out to Give Them, and you're exactly right. When he says this judge from Texas, y'all, man, we say y'all in Georgia. That's what we say. Write
How are
down
you
what
gonna
you say.
need?
You write down, guys. Do you say you all, you guys, y'all? What do y'all say? I say y'all. What do y'all say? Right? I say y'all every single day of my life. Write down what y'all say. Y'all. Let's see. Use guys.
That's northern.
Right.
How are you gonna need? 2 minutes?
Oh my
10 minutes,
God.
1 minute. Okay.
1 minute. The judge is like, God damn, you black people need it. How much time do you need? Judge Glanville's like, I need a three hour comfort break. We're gonna sit here for 1 minute while the prosecution again gets its shit together. Guys, how many times have we been waiting on the defense? None. How many times have we been waiting on the prosecution? Every single time. But with Judge Glanville would have hid all of this incompetence, would have hid all of this unpreparedness. In fact, Judge Glanville told Brian Steele that he was unprepared. Judge Glanville told Brian Steele that.
Here's the thing, aging begins in your cells. Start supporting your cell health today.
And give to the court the cause that we have identified within the wiretap that contain co-conspirator statements.
Okay.
One of the wiretaps.
One of the wiretaps.
Is this his first time actually
One of the
speaking?
wiretaps.
I don't remember him talking at all.
Your Honor, this wiretap is it's a 6,000 page PDF where you can open up audio links. It has the date, the time.
Okay.
90% of them have what they call reference numbers, where while they're watching the wiretap, they'll give it its own 4-digit identifier.
Okay.
Every now and then, the reference number will just say 0. I don't know why. So I think what makes the most sense for purposes of getting, I wanted for the defense to know where this specific audio is. I'm going to give, for most of these, I have the reference number, the date, the time, and sometimes I also have the PDF page on that document. So that's how I'm going to reference it for all parties to speak off the same sheet of music.
Okay. Give me a ballpark before you do that of how many there are.
Yes, Your Honor. Let me count these up.
Ballpark. 5, 20, 100?
More, they will be closer to 50 to 100.
Okay. So instead of standing there and reading them all, do you have them in writing?
I do. With what I can do is take, a lot of these have notes like next to them of things that stood out. And so what I can do is create a
Okay.
document that has the date, time, reference number.
I would
and
think that would be
PDF page.
easier for everybody than making sure they write it all down correctly. Tell me this, what witness is this a wiretap of?
So, Your Honor, there's two wiretaps. The specific one I was going to start with
Okay.
is Demekion Garlington, who is a
Okay.
severed co-defendant.
Right, okay.
And I believe almost the entirety of these wiretaps will come in through Detective Ibarito, a Atlanta Police Department gang detective, who I think is probably ballpark 50 plus witnesses down the road.
Okay. Okay, all right. So there are going to be a series of alleged co-conspirator statements that are in the wiretap of Garlington. I think I would imagine that the state could speak to me right now about what it is that you will use to establish that Garlington is a co-conspirator. You, Mr. Atkins, will put together the list of all of the details, and you will email that to all of the defense attorneys and the court today.
Yeah, sure.
And we can maybe do the litigation of that, maybe that week in August. So I will need at least the portion of the statements that is at issue as well.
Yes, Your Honor.
Okay, so that is one set of co-conspirator statements. You mentioned another wiretap of someone else.
Correct. Of Mr. Sumlin,
And
who was
is-
also, he has pled guilty, but he was one of
Okay.
the 28 indicted defendants in this.
So you've done your proffer for that one. That one will be easy if he pled guilty.
Yes, Your Honor. Yes, Your
All
Honor.
right, Sumlin. And you can do the same for him.
Correct.
Okay,
And
perfect.
he has less, it's hard for me to ballpark the.
That's fine. I just was like, if it's two, you can read them out, but if it's some huge chain, then it's easier to just give them in writing.
Yes, Your Honor.
Okay, all right. So that is two further potential co-conspirators who have statements we will need to litigate. Whom else?
Your Honor, we have an additional co-conspirator statement from Mr. Copeland, a jail call.
Okay.
That's a part of the 5
Jail calls.
about a portion of the 5 jail calls.
All right, hang on. Is that a surprise to anybody? Do I need to do a back and forth about whether it's fair for that to come in? Okay, that was part of the notice, so that one's good.
I don't think it's part of the notice, but
They don't think that was part of the notice, but they're willing for y'all to say that's good.
but there was just a portion of that call that the defense objected to, but we can talk about that.
Okay, and all right, well, y'all have already been litigating that, so I'm gonna call that one good in terms of notice. Whom else?
This judge is tired of these black people. Just tired of them. Look at her face. She's the head tilted. Jesus. Get your shit together. Yeah, shout out to this white
All right.
dude sitting in the middle.
Question.
He's
So I'm looking at
suffering.
this November 2023 notice, and at this stage, when it was filed, they're talking about witness A. Y'all all know who is referred to in each of those at this point? Okay.
Yes.
Okay.
We filed a supplement that wasn't filed. We gave to them.
Okay.
Witness A.
All right.
Shout out to Kelly Kale with 2L. Congratulations, Kelly Kale.
Yeah, today's bar exam day too. A lot of people taking the bar.
Is it really?
Yeah.
Can you provide to this judge whatever that supplement was so that I know? Thank you. Do y'all, deputies, do you know whether lunch is here yet for the, okay, why don't we break for lunch? Be back at, how long, practically speaking, do y'all actually need to get everybody?
All right, they're coming back at 120, guys. They're coming back at 120. Let's just cut to the chase. Cut to the chase. Listen, I got to eat lunch too. All right. So shout out to everybody. AV, I neglected to ask you if you have any cash apps.
Yeah,
But while you are getting that ready, and we're definitely going to read those out. Let me shout out to Marie, my most consistent supporter. Send me $20 on the cash app. Thank you so much, Marie. The beautiful Carolyn, Carolina, never know which one it is. Send me $10 on the cash app. Thank you so much. And the beautiful Dana. Dana C, thank you. Sent me 25. Says 20 is 25 for the stream. She gonna buy me lunch today. Thank you so much, Dana Carter. All right, AV, do you got any that you want to shout out as well?
Yeah, shout out to Drew Beats, sends me $4, who says 2 secret meetings, mistrial now. Drew Beaks is back again with 3. It says mistrial with double jeopardy / thug will go free. Thank you so much, Drew. Shout out to Full Drinking, Half Thinking with $15. Says beverage on us. I love that y'all do that for me. Thank you. Really appreciate that. Shout out to Candy Yates with $20. She says, good morning, sis. Good to see you. Good to see you too, Candy. Hope all is well. Shout out to Audrey, who hits me with $10. No comment, no question. Pure love of the game. Thank you, Audrey. Shout out to Michael Love. He hits me with 80. He says, for dinner. This is he does my dinners.
This is like Mediterranean tonight. Or what was he gonna get you now?
He said he sends 80. He says for dinner, new judge. He says fish, tilapia, and yellow rice.
That's kind of Mediterranean.
It is good.
I kind of called it, right?
Yeah. Shout out to Marie with the $20. She hits me with the heart. Thank you so much, Marie. Shout out to Carolyn, who hits me with $10. No comment, no question. Pure love of the game. Shout out to Kelsey with $20, who says high value woman. Thank you so much, Kelsey. Shout out to E. Capone with $5. Says Glanville, one of the girls. Thank you so much, E. Capone. And then lastly, shout out to Prince, who sends me $10 and says thank you for your time. Thank you, Prince. Thank you so much for watching.
That is what's up. So thank you so much, guys. Shout out to Sassy Touch. All right. Shout out to Mitch. Mitch says, if we get a mistrial, can you swap out the blue suit for a green slime and slime green? All right, slime green. Let's also listen. Thank you guys so much. And we're coming right back 1:20. So we're going to get something to eat. Really want to thank Whitney. Somebody write Whitney in the dang chat, man. Whitney is the sponsor of the stream, the sponsor of the day. And this has been a crazy, crazy morning. And Whitney sponsored it all. Big shout out as well to Innocent Bystander Channel. Thank you so, so much. Really appreciate that. And again, thank y'all for spamming Whitney's name. All right, everybody, let's get something to eat. We're going to come back at 1:20. All right. I know we have been reviewing all of these shenanigans, what is going on in the middle of court. Having said that, whatever AV and I say, please remember, guys, that none of this is legal advice. I am not your attorney. I am the lead attorney, and I'm here to help you lawyer up. All right. See you soon. Shout out again to Miss Whitney. See y'all right back here at 1:20. All right. Fair and square. See you right back.